Court officer. Your Lordship's mic is off.
Lordships, I appear for the serial number 1, my lord. Orders. I'm not. Audio is not coming in, my lord.
Can you come to court?
Yes.
Someday I will fix. Which day you will come?
My lord, we don't have a copy of this letter which is there.
Don't worry about letter. It is addressed to the court saying that you can't keep the matter pending all through. It's your duty to dispose of. That is what he has warned us, and rightly he has warned us. We can't keep it for 8 years like that.
I'm obliged, my lord, but copy was not served, so I don't know. But yes, my lord, if they are closing it, they can close, my lord. The letter.
Not close. They are saying here this matter. You can't go on delivering the lectures. Decide this matter is their version to us, not to you.
Yes, my lord. We
ready? Are you ready in the matter?
Oh, my lord, you can fix a date, my lord. I will argue
it. Call this matter next week. All right. Noted the letter dated 6/12/2024 sent by Joint Commissioner of Commercial Taxes, Legal Affairs, Bengaluru, requesting the court to expedite hearing. First, all right.
Much obliged.
But generally, they should address their lawyers. But anyway, this has happened.
And a copy also, my lord.
What letter? No, it need not be given to you. It is addressed to the court. Yes. Yes. You know, waiting for TCR. What is that? Why it is?
Because cross-examination, they have admitted that.
Correct. Did you get them? LCR has come now.
That's,
Awaiting.
I also direct counsel.
Learned AGA to secure TCR forthwith. First off. Call next week. Entry ಮಾಡಿದ್ದೇನು?
Entry model next. Entry model next.
That's all right. Entry model to continue. Call a week after next.
We
Okay.
recollect my lords last time.
All right, then recollect the entry model right. Next time.
My lords, the other connected matter, my lords, 183, the delay of been condoned, my lords, 275.
183.
Subject to 2 books of Shatavani Ganesh be provided.
Which books you are going to give?
So right now, my lords, I'll provide my lords, Riddles in Hinduism, my lords, by Dr. Ambedkar, my lords.
ಯಾವುದು?
Riddles in Hinduism.
ಬಡಿ. All right, ಕೊಡಿ. All right, ಕೊಡಿ. ಏನದು book ಕೊಡಿ. Book ನೋಡಿಲ್ಲ. Just I want to see that. Riddles in Hinduism. It's a very good book it is. Yes. ಕೊಡಿ. ಇದೊಂದು 5 ಕಾಪಿ ಕೊಟ್ಬಿಡಿ. ನೋಡಮ್ಮ 1 ಕಾಪಿ ಇವರಿಗೆ. All right, ಬರ್ಕೊಳ್ರಿ. Appeal is filed after broking a delay of 275 days. First, an application supported by affidavit seeks its condonation. First off, an explanation, the learned counsel appearing for the assessee opposes the application saying that delay is too long and explanation offered is not plausible. First off, having heard learned counsel for the parties and having perused the appeal papers, we are inclined to allow this application. Explanation offered is plausible, although there is scope for more plausibility. First off, a delay is not that long, and matters older than this are still languishing in the court corridors, cupboards. First off, it is not that had this appeal been filed in time, by this time it would have been heard and decided. First off, justice warrants condonation of delay. Next, in the above circumstances, application is favored, delay is condoned. Of course, subject to the condition that the appellant shall present 5 books, namely Riddles of Hinduism by Dr. Ambedkar, Riddles in Hinduism, Dr. Ambedkar, 2 Bar Association Library, and 1 book to the council appearing for the assessee. This to be done within 2 weeks. Okay. Call this matter along with 183. 183 of 2023. Yes, next.
Filing memo for additional substantial question of law, my lord.
What is that? Yes.
Your Lordship, additional substantial question of law, my lord. In this case, the tribunal has set aside the
Is it already admitted?
not yet admitted, my lord.
Not yet admitted.
Yes, my lord.
Your Lordship, I appear for the respondents. A copy
Yes.
has not been served upon us, Your Lordship.
Your Lordship, a copy is ready, my lord. Their counsel. my lord,
Notice
if-
ಆಗಿತ್ತೇನೋ?
Notice agid.
ಮತ್ತೆ ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡ್ಬೇಕಲ್ಲ?
Copy ಕೊಡ್ತೀನಿ.
ಯಾವಾಗ
So nobody is here. I will just scan it and send it, my lord. Today only I will send it.
Post this matter after panel counsel sirs copy of the memo on the advocate appearing for the assessee and not otherwise. Okay. Fifth. Sanmati,
For time being, it may be dispensed. At the time of final reading, we'll file the.
all right. A requirement of filing a written submission dispensed with, since matter needs to be heard. Okay. Yet to be heard. Matter is yet to be heard. Okay.
For the appellant ones.
Ah.
We have complied with the conditions of this honorable court.
You have given the
Only thing is we have not filed the memo, my lords.
all right.
Uh,
Counsel. for
Within
the-
2 days, I'll, 2 to 3 days, I'll
No,
file.
not necessary, not necessary. If you have said, we believe you.
We have,
But learned government advocate submits that the condition subject to which the order was recalled, recalled, condonation
delay was condoned subject
to
to,
which delay was condoned is complied with. First stop, there is no reason to doubt him. Okay. ಆಮೇಲೆ ಫೈಲಿಂಗ್ ಆಫ್ ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ dispensed with. Yes. Next.
Lodge, we call it after 2 weeks. Mulaj,
2
let
weeks,
us see.
call after 2 weeks. Next. Sanmati,
Needful done today, my lord.
needfully stated to have been done, registry to verify. Okay.
That's for the respondent.
Ah.
The Lords had disposed of this matter
Ah.
in December 2023.
Filing of complaints.
Adenagide, my Lords may look at the judgment copy.
There.
That's the state government, that's the last page, page number 6. Within 4 weeks, they were directed to restore the revenue entries and that's report compliance. That's today we are in Jan 2025.
Therefore, what you have done?
That's I appear for the respondent. It was the appellant who had to do that. That's they've not done that. Contempt ಹಾಕೊಂಡ್ವಿ, contempt ಅದನ್ನು 2 weeks ಅಲ್ಲಿ ಮಾಡ್ತೀವಿ ಅಂತ undertaking ಕೊಟ್ರು.
ಅದು recall ಹಾಕೊಳ್ಳಿ.
That's had, Malad sir was sitting with Honorable Chief Justice.
Correct, recall ಇದನ್ನ ಕೊಟ್ಟಿರ್ತೇವೆ ಅದರಲ್ಲಿ ಏನು ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿರ್ತೇವೆ ತಾನೆ?
Yes. in
ಮತ್ತೆ
that,
recall ಹಾಕಬೇಕು.
Yes, that's this also they had to report compliance. They've not done that.
No address required. Yes, liberty is reserved to move appropriate application in the disposed of contempt matter.
Great.
Brother, why unnecessarily matters are pending? ಅವ್ರಿಗೆ ಅಡ್ವೈಸ್ ಮಾಡ್ಬೇಕು. ಟೈಮ್ ಕೊಟ್ಟ ಕಂಪ್ಲೈ ಮಾಡ್ತೀವಿ ಅಂತ ಅನ್ಕೊಂಡು ಹೇಳಿ ಅಶ್ಯೂರೆನ್ಸ್ ಕೊಟ್ಟು ಕಂಪ್ಲೈ ಮಾಡ್ಲಿದ್ದಾರೆ. ಯು ಹ್ಯಾವ್ ಟು ವಾರ್ನ್ ಯುವರ್ ಕ್ಲೈಂಟ್ಸ್.
Any number of.
ಬಿಗಿಯಾಗಿ ವಾರ್ನ್ ಮಾಡ್ಬೇಕು. RN ಬೈರಾರೆಡ್ಡಿ ಇದ್ದಾಗ ಯಾವ್ದಾದ್ರು ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಹೇಳಿದ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಆಫೀಸರ್ಸ್ ಕೇಳಲಿಲ್ಲ ಅಂದ್ರೆ ಗೆಟ್ ಔಟ್ ಅನ್ಬಿಡ್ತಿದ್ರು. ಅವ್ರನ್ನ ಎಂಟರ್ಟೈನ್ ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳ್ತಿದ್ರು ಕೋರ್ಟ್ನಲ್ಲಿ. ಡೋಂಟ್ ಎಂಟರ್ಟೈನ್ ದೆಮ್ ಬಿಕಾಸ್ ದೇ ಆರ್ ಬೌಂಡ್ ಟು ಒಬೇ ಯುವರ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್. Just tell.
This is the direction of a division bench, my lord. I mean, there is no.
ಅಲ್ವಾ ಅಶ್ಯೂರೆನ್ಸ್ ಕೊಟ್ಕೊಂಡು ಕಂಟೆಂಪ್ಟ್ ಡ್ರಾಪ್ ಮಾಡಿದ್ದೆ ಅದಕ್ಕೆ ಅಂದ್ರೆ ಅಶ್ಯೂರೆನ್ಸ್ ಕೊಟ್ಟಿರಿ ಅಂತ. ಹಿಂಗ್ ಮಾಡಿದ್ರೆ ಹೌ ದೇ ವಿಲ್ ಗೆಟ್ ಫೇತ್ ಇನ್ ದ ಜುಡಿಷಿಯರಿ. ಅಲ್ಲೇ ಡ್ರಾಪ್ ಮಾಡ್ತೇವೆ, ಇಲ್ಲಿ ಅಶ್ಯೂರೆನ್ಸ್ ಹೋದಾಗ ಇಲ್ಲ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕುವಂತೇವೆ, ಬೇರೆ ಇದನ್ನ ಮಾಡ್ಕೋತ ಕೊಡ್ಬೇಕಾಗ್ತದೆ. ನೋ ಯು ಹ್ಯಾವ್ ಟು ಅಡ್ವೈಸ್ ಯುವರ್ ಕ್ಲೈಂಟ್. ಓಕೆ, ಎಸ್. Yes, Madam Moni.
This objection raised regarding the jurisdiction.
Jurisdiction.
Petition should have been filed before Dharwad.
Pecuniary, Dharwad bench. ಮತ್ತೆ ಅಲ್ಲೇ ಹಾಕ್ಬಿಡಿ.
Sustain ಮಾಡಿದ್ದನ್.
ಅಲ್ಲ ಎಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದ್ದು ಎಲ್ಲಿದು?
ಆರ್ಡರ್ ಇಲ್ಲ. ಹೊಸಪೇಟ್.
ಹೊಸಪೇಟ್ನಲ್ಲಿ. Then it comes to ಧಾರವಾಡ. ಧಾರವಾಡ ಬರ್ತದೆ.
But I may be permitted to withdraw.
ಅವ್ರು ಮಾಡೋದು ಬೇಡ, ನಾವು ಮಾಡ್ಬೇಕು.
Lord, I'm filing a memo to withdraw the.
Why do you withdraw? You will send it to that bench only.
That will take some time.
Okay. Counsel for the petitioner, in view of the full bench decision of this court in so and so, seeks leave of the court to withdraw the petition appeal so that it can be presented before the Dharwad bench of this court. First off, leave granted and appeal is permitted to be withdrawn. Appeal is disposed of as having been withdrawn with liberty as sought for. First off, the period spent after filing of the during the period between filing of the appeal and disposal, its disposal to be discounted while counting period of limitation.
Time.
First off, registry to return the certified copies after retaining Xerox copies thereof in the file. Okay. ಅಲ್ಲೇ full bench judgment ತಗೋಬೇಕು. Justice Devdas ಮತ್ತು Sharma Sahib, one more judge. Yes.
My lords, matter stands covered, my lords. Have to be dismissed, my lords.
Padi.
Same assessee, my lords.
Same assessee.
Same assessee, my lords.
In view of that 874. This is no more not sick. No more not sick matter.
Yes, my lords. That was 1718, my lords. Right now, the
Learned counsel appearing for the appellant, having argued the matter for some time, very fairly submits that the subject matter of this appeal is substantially similar to the one in ITA number 65 of 2024 between the Principal Commissioner of Income Tax, versus SAP India Private Limited, heard and disposed of by a coordinate bench of this court, wide order dated 19/8/2024. First time. The coordinate bench at paragraphs 7, 8, and 9 has observed as under. In Bere Paramadbe. Next one. In view of the above, no substantial question of law would arise in this case too. And therefore, appeal is dismissed in limine. First, registry to send a copy of this judgment to the assessee by speed post immediately. But
This is below monetary limit, my lords. This will have to go, my lords.
sorry. ಯಾವುದು ಇದು
Below mark.
CBDT circular dated
5/24, my lords.
5 of
24. Para 9.
9 of 24.
9, my lords. Para 9. Para 3.
A coordinate bench of this court in ITA number 207 of 2020 between the Commissioner of Income Tax versus Srinivasa Educational and Charitable Trust, heard and disposed of on 30 September 2024, has held that because of monetary limits, such an appeal is not maintainable. First stop. Next part, the subject matter of this appeal also is almost is substantially same. First stop. Next part, in view of the above, appeal is held to be not maintainable and accordingly disposed of with the same terms as are expressed in the coordinate judgment. Okay.
A week time may be granted. 1 week time.
Third time,
1 week. Finally, I will do it. Maybe
one
perfect.
book,
1 week.
one book.
ಇಲ್ಲ.
ಹಾಗಂದ್ರೆ ಮೂರ್ ಸರಿ 4 ಸರಿ ಮಾಡ್ಲಿಕ್ಕೆ ಇವ್ ಅದು ಸಪೋಸ್ ಅವ್ರು ಹಿಂಗ್ ಮಾಡ್ತೀವಿ ಅದನ್ನೇ ಮಾಡ್ತೇವೆ.
Your Lordship, serial number 13, I will do it today only, my lord.
All right. Compliance to be done within 3 days.
Unless I may be permitted to take notice.
Emma?
Permitted to take notice.
In the meanwhile, issue notice, Srimati so and so appears for the assessee, compliance to be done within 3 days. Okay. Next. Failing which appeal stands rejected. Yes.
This also within 3 days, I will do it.
All right. Compliance within 3 days. Okay. Failing which appeal stands rejected. Yes. Arisha?
In this matter, I filed my wakalat, your lordship.
Ah,
My name has not been shown.
your name is not shown.
No, your lordship.
You appear for whom?
I am appearing for the appellant, your lordship.
Harish is retiring
He's
or
given,
along with him you appear?
no, your lordship, he is given an NOC, your lordship.
Okay. On request, learned counsel Sri Harish VS is permitted to retire from the case. First off, learned counsel Sri so and so appears in his stead. Complies within 1 week. All right. Any complaints important is there?
Important is
All right.
2 weeks, maybe.
2 weeks for compliance. Finally, next time heavy cost would be imposed. Okay. Yes, Manu.
Heard it for a short while the other.
ಏನಿದೆ cover ಇದೆಯಲ್ಲ ಏನಿದೆ R2 and R3.
My lord, I am for R2, my lord. R2 is the authorized officer of R1. I'll take notice for R2.
Shri,
Aniket BC. Aniket BC.
perfect. Shri, so and so appears for respond number 2. But 3 ಗೆ?
Lord, respond number 3 was set ex parte before the debts recovery
Forward.
tribunal.
Forward.
Notice to respond number 3 is dispensed with. Since he stated to, it is said that he was placed ex parte
Ex parte before the debts recovery
before
tribunal.
the DR 18 or DRT? No?
DRT, ma'am.
DRT. Ah. Yes. Ha.
Please.
ಕೊಡಿ. Yes, just freshen our memory.
My lord, this was a matter, my lords, where
Ah,
an order of the debts recovery appellate tribunal is under challenge.
yes,
In respect of,
18 order.
please, my lords,
18.
an order under section 18.
13.
Only in respect, not really on merits, only in respect of two questions. One, whether because there are, please. One, my lords, because whether there are two separate appeals that I have filed, should I make?
Pre-deposit ಸಂಬಂಧಪಡುವಂತದ್ದು.
Please.
How many pre-deposits? Is it whether pre-deposit is cause specific or loan specific ಅಂತ ಕ್ವೈನ್ ಮಾಡಬಹುದು.
Please,
ಅಲ್ವಾ?
please, my lords.
You said Madras High Court said like this,
Please,
and Kerala High Court said like this.
please, my lords. Then, my lords, very helpfully, my lords, your lordship asked me to look up the parliamentary debates, etc., which I have done.
Yes, what the debate says.
Please, my lords, may I show them one by one, step by step? It's two sets, no?
ನೀವು ಪಾರ್ಲಿಮೆಂಟರಿ ಡಿಬೇಟ್ಸ್ 5 ವರ್ಷದ ಕೊಡಿ ಅಂತ ಕೇಳಿಲ್ಲ ಮನು ನಾನು. ನಾ ಕೇಳಿದ್ದು ಅದಕ್ಕೆ ಸಂಬಂಧಪಡೋದು ಅಷ್ಟೇ.
ಇಲ್ಲ, my lords, I've put everything together now.
Okay. Share copy with your friends also.
Yes, my lords.
At least relevant copies ಆದ್ರು.
No, my lords, I have full set.
But
So for court, second set? Oh, this is only one. My lord,
ಏನ್
before,
ಹೇಳ್ತದೆ ಡಿಬೇಟ್ ಯಾವ ಪೇಜ್?
my lord, before I go to the debate, may I just mention two facts, my lord?
ಬಡಿ ಸೆಕ್ಷನ್ ಓದಬೇಕಾ?
My lords,
ಓದಿ.
section 17 and 18, I will just mention it.
Read.
My lord, section 17 as it stood earlier, before the Supreme Court struck it down in Mardia.
Mardia Chemicals.
Please, my lords, in Mardia Chemicals, section 17, which is the original proceeding, there was a condition of pre-deposit of 75%, which could, however, be waived fully.
Full discretion with the court.
Please, my lords.
18 has restricted the extent of waiver.
Please, my lords. At that time, when 17 had 75% pre-deposit, 18 did not contemplate a pre-deposit at all, because in the original proceeding itself, 75%
Deposit.
was to be deposited. In Mardia, the Honorable Supreme Court struck down 17.
Which required pre-deposit.
Please, my lords. It is in that background that the legislature then amended section 18, did not reintroduce the pre-deposit provision in 17, but instead
Did it
brought
in
it in appeal. And in appeal, they said from 25% to 50%. Therefore, my lords, if I may request your lordships to kindly see 3 paragraphs in Mardia first, because the parliamentary debates specifically refer to Mardia. The changes therefore are made in light of what was the law laid down in Mardia.
Yes.
My lord,
Good. ಯಾವ್ದು page?
in the list of authorities, my lords, page 52, your lordship may please see. My lords.
5-2. But I vaguely remember
Please.
this aspect of the matter having been treated by myself and Maheshwari Saab in Dr. Vijay Mallya versus so and so.
I will check, my lords.
It is there.
Yes, yes.
If
my
I say it is there, it must be there.
Yes, yes. Yes, yes. I am not doubting that.
ILR 2018 or 19. Dr. Vijay Mallya versus State Bank of India or consortium of banks.
Please.
We have treated this aspect.
I will look it up straight away.
Anyway,
Please.
huh.
In
But
Mar-
this aspect,
Please.
whether in multiple appeals, if proceedings give rise to, whether in all appeals that a point should be made or not is not the subject matter of that one. But it's just philosophy underlying the requirement of making deposit.
Pre-deposit. Please, my lords, I will look that up straight away.
Lordship was sitting with Chief Justice Oak, I think.
No. Chief Justice, Honorable Chief Justice Maheshwari Saab. Yes.
In Mardia, my lords, in para 2, I am just mentioning section 17, the Honorable Supreme Court says is under challenge. In that light, the relevant paragraph your lordship will please find from para 60 onwards at page 93. The requirement of pre-deposit of any amount at the first instance of the proceedings is not to be found in any of the decisions cited on behalf of the respondent. All these cases relate to appeals. In that light, my lords, if your lordship will please see 61 on the next.
You are right. In the case of.
In the
Seth
case of Seth Nandalal, while considering the question of validity of pre-deposit before availing the right of appeal, the court held right of appeal is a creature of the statute and
They
while-
said whatever condition, if the legislature wants to impose, it can impose.
except my lords, the last four words, your lordship may please see.
It should not be unreasonable and onerous.
Please,
That's all.
please, my lords, precisely. I don't need to. Then your lordship may please kindly see para 64. The reasons why the pre-deposit condition is in fact set down. The condition of pre-deposit in the present case is bad, rendering the remedy illusory on the grounds that it is imposed while approaching the adjudicating authority of the first instance, not in appeal. There is no determination of the amount due as yet.
So it gives an indication that it is to secure repayment in a way of
Yes,
the
ma'am.
debts. Therefore, it cannot exceed what is due in your contention.
Please, my lords. And there is one reason where the Honorable Supreme Court says 75% in itself is onerous.
Not that itself is.
Onerous. That your lordship will find in Roman number 5.
Correct.
Then 3, 4 and 5, my lords, may also avail.
Onerous ಅಂತ ಹೇಳಿಲ್ಲ.
It
It will
says-
not be a meager amount.
Would not be a meager amount.
Onerous ಬೇರೆ.
Onerous is in 6. It will leave the borrower in a position where it would not be possible for him to raise any funds to make deposit of 75% of the undetermined amount. Such conditions are not alone onerous and oppressive, but also unreasonable and arbitrary. My respectful submission, my lord, says
In the light of this, it is enacted.
it is. 4, 5 and 6 may also avail in appeal because 4, 5 and 6 say the man has a security which the bank has already taken possession of. In those circumstances, where will he bring the money from? If the only property that he had is already with the bank.
Is it your case that you don't have any other property?
No, that's not my case.
Question is onerous. English courts have treated
Please.
the idea of onerousness. It is with reference to the person's standing and capacity.
Please.
It may look to be onerous. Suppose if I have to file an appeal against a particular order, I have to make 100% deposit. Onerous has something to do with the capacity of the appellant also. Suppose he is a multi-millionaire. He cannot plead. It's a onerous condition.
I bow down, my lords. There, my lords, my respectful submission is within the band prescribed, within the legislative band, which now is 25% to 50%, that would avail. But in determining what the provision means, a broad yardstick.
This is the amount of debt.
Please, my lords, that would be my
Right.
respectful. In that light, my lords, if your lordship will now see kindly the debate, which is at 104. Starts, my lords, at 104. The relevant paragraph your lordship will please find at 109. In the middle of the page, the Minister of Finance, Shri P. Chidambaram, Madam, I am grateful to the honorable members for the broad support they have extended to the bill. I think the principal question that is worrying some members is this: why was an ordinance promulgated? The judgment of the Supreme Court in Mardia Chemicals was passed on 8th of April 2004. I have no doubt in my mind, etc. Then the rest, my lords, is on why a ordinance was necessitated. I just wanted to read this line to demonstrate that Mardia was very much present in the mind of the lawmaker when these amendments were proposed. In that light, your lordship may please see the next paragraph now. Madam, these are main changes. As the honorable members know, we have, in deference to the observations of the Supreme Court, deleted subsection 2 of section 17. And we have also introduced a provision by which the borrower will be given an opportunity to state his case before measures can be taken under 4 of 13. And immediately the borrower can challenge it before the tribunal. If the tribunal upholds the claim of the lender, then the borrower wishes to go for an appeal, at that stage, a provision has been introduced where the borrower would have to deposit 50% of the amount which has
As
been
was decided as owing from him.
Then, my lords, the next paragraph, at the first stage, he deposits nothing, and at the second stage, the appellate stage, he would have to deposit 50%. I think this is a fair provision. This balances the interest of both the lender and the borrower. These the very next paragraph. At the first stage, he deposits
Correct.
nothing. And at the second stage,
So balances the interest of both the lender and the
borrower, and the finance minister says, I think this is a fair provision. Therefore, my lords, this is what was operating in the mind of the legislature while enacting this provision.
Okay.
Then, my lords, in the next sentence, in the next paragraph, just one sentence in the second line, I do not think, in the middle of the page, in the very next paragraph, second line, I do not think we should look upon banking as anything but a business. Parliament, therefore, my lords, did not really place the banks on the kind of pedestal that seems to be there.
Well, where are you reading?
My lords, at page 109, the last paragraph of page 109, Madam Chairman, some reference was made to NPAs and the persistence of NPAs. It is true that there are NPAs, but as credit expands, there will be certain amount of default. Then, my lords, I do not think we should look upon banking as anything but a business. Like some businesses will fail, in banking also some loans will fail. Therefore, my lords, the parliament is saying this is just another business, but we have made certain special provisions for smooth functioning of this business.
Yes.
In this slide, my lords, then your lordship may kindly see, my lords, 110, the third paragraph from top, which begins with Madam Chairman.
Yes.
In that, my lords, about 6 lines from top, at the right-hand side of that paragraph, we have also given power.
We have
Also given power to the appellate tribunal to club all connected cases lying in various debt recovery tribunals into one tribunal. These are simply housekeeping changes in order to clean up some provisions where drafting was deficit, but the main provisions are to address the defects pointed by the Supreme Court. Section 17(2) and the opportunity to be given to the borrower. Largely, my lords, this is what inspired the changes. In the statement of objects and reasons also, my lords, a specific reference is made to Mardia.
Yes.
I just pass on the relevant portion of the book, my lords, where a specific reference is made to Mardia to demonstrate, my lords, that the decision in Mardia was looming large when these amendments were carried out.
What is this book? The author's note.
No, my lords, this is the statement of objects and reasons for the 2004 amendment, where there is a specific reference to Mardia. The Honorable Supreme Court, in the case of Mardia Limited, inter-alia held.
Correct.
Therefore, my lords, it is not just in the debates, it's also in the statement of objects and reasons of the statute. Therefore, this is a consistent recurring theme that this amendment is made in the light of Mardia, keeping in mind the fact that any onerousness would be struck down by the Honorable Supreme Court. In that light, my lords, my respectful submission is, can the appeal provision be so interpreted? Now, my lords, if I may come to section 18, in fact, my lords, it fell from your lordships itself on the last date as to how it could be understood.
No, that was only one thought. Because you started, I said that way. When they start, I may say something
Please.
against or something in their
No,
favor
no,
also.
lords.
This is nothing but a court, when argument takes place, it's a marketplace of ideas.
Please.
That's all. We may buy some ideas, we may sell also, we do not know. More often than not, it's the bar which sells the ideas to the judges. We buy, no, it's inevitable also for us
Please.
as consumers. Yes.
Lords, in the proviso to section 18,
18. ನಮ್ಮ ಇದನ್ನ ಕೊಡಿ ಅವ್ರಿಗೆ ವಾಪಸ್ ಕೊಡಿ.
surface.
Yeah.
In the meanwhile, may I read, my lords? The second proviso, or if I may read just the entire provision, my lord.
Entire provision ಓದ್ಬೇಕು.
Please, any person aggrieved by any order made by the Debts Recovery Tribunal under section 17 may prefer an appeal along with such fee as may be prescribed to the appellate tribunal within 30 days from the date of receipt of the order of the Debts Recovery Tribunal. Provided that different fees may be prescribed for filing an appeal, by the borrower or by the person other than the borrower. Provided further that no appeal shall be entertained unless the borrower has deposited with the appellate tribunal 50% of the amount of the debt due from him as claimed by the secured creditors or determined by the debts recovery tribunal, whichever is less. Provided also that the appellate tribunal may, for reasons to be recorded in writing, reduce the amount to not less than 25% of debt referred to in the second provision. My respectful submission, my lords, is on a plain reading. While 18 subsection 1 refers to an order of the debts recovery tribunal, the second proviso does not refer to, for instance, my lords, the amount indicated in the order. Makes no reference to the
particular case
order
law.
issue.
He was asking for counter against that.
Your side, huh? Case law.
Yes.
For a change, there should be some different voice also.
Therefore, my lords, my respectful submission is the legislature deliberately kept the language of the second proviso to the words, my lords, debt due. These, in my respectful submission, are the operative words. And it is not just debt, it is debt due. Lords, my respectful submission is the word debt is defined in the SURFACE Act. It is defined, my lords, in section 2HA.
A. HA. Debt shall
Please,
have the meaning.
debt shall have the meaning assigned to it in clause G of
83 Act.
section 2 of the RDDB Act.
And includes.
And includes. The includes portion, my lords, is for very specific circumstances. The general definition of debt is found in the RDB Act. In 2G, if I may read that, means any liability inclusive of interest which is claimed as due from any person. These are the operative words. Thereafter, it goes into specifics. Means any liability inclusive of interest which is claimed as due from any person. Therefore, my lords, the definition of debt includes the words due. Nevertheless, Parliament said debt due. My respectful submission is that those two words were used in conjunction in order to, it would, my lords, accrue both against me and to my benefit. It would accrue against me, my lords, because after 4 years of, for instance, a matter pending before the tribunal, if in the appellate tribunal I were to say the amount has to be reckoned as mentioned in the section 13(2) notice, it would simply put a premium on me to drag the proceedings. Therefore, it's not just debt, it is due. Debt due at the point in time when the deposit is being made. Therefore, my lords, if the Parliament was so cognizant to fix the quantum on the basis of what is actually liable as on the date of preferring an appeal, then, my lords, my respectful submission is one can hardly say this is a sum to be paid per appeal. Because nowhere is that language found in section 18. Which is why, my lords, my respect.
In other words, condition of pre-deposit to be construed as debt specific.
Please, ma'am.
And not appeal specific.
Not appeal specific.
That's your contention.
That is my respectful submission. Then, my lords, my respectful submission is in the facts of this case as to whether there were really two separate appeals. If I may just show the order of the Debts Recovery Tribunal, the Debts Recovery Tribunal itself.
Which are the two appeals filed actually?
My lords, one appeal is filed against measures under section 13(4), symbolic possession. The other is filed against auction notice and subsequently auction sale.
That takes place under which provision of law?
My lords, both in that sense take place under 13(4) itself.
They take place under 13(4).
13(4). The power emanates from 13(4). Thereafter, my lords, it goes into some of the rules which permit sale of property, Rule 8. deals with sale of immovable property.
Auctioning of property.
Please, my lords. Section 13.4.A says, take possession of the secured asset of the borrower, including right to transfer by way of lease, assignment, or sale for realizing the secured asset. Rule 8, my lords, crystallizes the manner of exercise of this right, which is
Let us see what they will say. Any other point you want to?
There is one other point, my lords, which is, I just want to show the order of the Debts Recovery Tribunal to submit, my lords, that the Debts Recovery Tribunal did not consider these two as two separate or distinct matters.
That it treated it as one appeal.
Lords, because there were two separate appeals, the Debts Recovery Tribunal writes a preamble saying one appeal is sequel to the other.
No, that equality is another thing. One appeal is one appeal. Both appeals are one appeal only. That's not the terminology employed by the tribunal.
My lords, if
No,
the
question
terminology
is-
employed is sequel.
No, sequel is, that's a different word.
Please,
Sequel has its own meaning.
please.
Not that way. Anyway, two appeals are filed.
Two appeals are filed.
Two appeal books are filed.
Please, my lords.
Two separate wakalats are filed.
Indeed, my lords.
Is it not?
Indeed.
Two causes of action are there.
Please, my lords.
Let us see. Let us see. You mean to say both these appeals should be treated as one appeal only?
Practically one appeal because the Debts Recovery Tribunal says
Okay.
grounds urged are common to both
So
applications.
suppose that may not be the correct. Grounds may be same. Relief may be different.
Lord, I
One
think-
is
Please,
one is setting aside the auction note.
please, my lords.
The other is the
Setting aside the measures under
13.4.
13.4.
13.4.
Lords, let me put it this way, my lords. If the first appeal were to be allowed, that is 13.4,
Second becomes infectious.
it falls on its own.
Suppose if first appeal is rejected,
The second
13
appeal,
still survives.
it may still have legs to stand.
Therefore, two appeals.
Therefore,
Anyway,
two
let us see. I have understood your, we have understood your point now. What you want to say is,
please.
this one only, again to repeat. Generally, I am against repetition. Repetition is a torture. Anyway, sometimes you have to repeat. We have to ignore res judicata and speak again and again and again. Same thing. You say that pre-deposit enacted in section 17 was struck down because of Mardia. Then Parliament intervened and left Mardia's rule as it is in 17.
Please.
But brought some change in 18 to the effect that pre-deposit has to be made if you want to challenge the order.
Please.
We coupled with the discretion to the tribunal to waive off a part of that.
Please.
This is the position.
Please.
You say this is not appeal specific, going by the debate of Mr. Chidambaram in the parliament.
Please.
It is amount specific, and that amount is debt due.
Please.
As defined under 2HA,
Please.
which goes to 1993 Act again.
Please.
That's your case.
That's
understood. Let us see what they say.
There is another part to my case,
Ah.
which is again on the words debt due. Lord, my case is there was a co-surety who is a co-surety along with me. A sum of rupees 43 crore is paid by him.
For appeal,
No minutes.
is already paid
In
towards the debt.
satisfaction of the debt.
Debt.
The bank also receives about 113 crores from the National Company Law Tribunal pursuant to liquidation proceedings of the principal borrower. The sum of 113 crores is correctly deducted from the calculation of debt due from me. Because the principal borrower is, because the
Deduction is given.
reduction is given. My submission is the same 43 crore that a co-surety has paid should also have been reduced on the same yardstick or on the same principle.
If that is added, your liability to pay pre-deposit will be lessened.
Please.
That
That is my second.
let
point.
us. Yes, sir. One second, sir. 1 second. What Madras said, Madras agreed with you.
Madras agreed.
Agreed. What Kerala said,
Kerala also agreed. my
Charlie,
lords.
Justice Charlie's judgment.
Para
authority,
39
na?
also agreed. Both of them are in my favor.
Universal. Okay. No other high court has taken any discordant view for Madras and Kerala?
Not that. I
Not
put
yet.
it.
Okay.
Lord, one of the factors to be considered by my lords while considering pre-deposit is also conduct, which your lordships have held in the division bench judgment in 2019, which is Lordship Justice by this court on an earlier occasion when my friend, when the petitioner had approached this court in respect of the very same dispute. These are the observations that are made. His conduct was found fault with, my lord. This is the order dated 16th March 2023 in WP number 15632 of 2021.
Yes. This is on what proposition?
This is on the proposition of conduct, my lord.
For 1 minute, kindly be seated. I will just make my notes so that I may not get confused with that. Mr. Manu Kulkarni. Only notes. Kutwali. Mr. Manu Kulkarni submits the requirement of pre-deposit as was enacted in section 17 came to be diluted by virtue of apex court decision in Mardia Chemicals, and thereafter Parliament intervened to leave 17 after quashment as it was and to change 18 to the effect that the appeal has to be accompanied with a pre-deposit of debt due, coupled with discretion to the appellate tribunal DRAT to waive off a part of that. First, he draws attention to the parliamentary debates in that connection, more particularly the statement of the then finance minister that the change brought about was fair. First, next point. He also argues that the terminology of section 18, more particularly the term debt due, gives abundant indication that the amount to be made pre-deposit should be viewed from the point of debt due and not from the point of multiple appeals. First, in other words, according to him, the requirement of pre-deposit of appeals specific. First, in support of his contention, he banks upon Madras High Court judgment decision and Kerala High Court decision. First, next paragraph. Secondly, he argues that the action that led to filing of the appeals had fallen within the precincts of section 13 of the Surface Act 2002, and therefore, though two appeals are filed, virtually they are one and the same, substratum being substantially same. First, last. Thirdly, he argues that certain sums of money have already paid by the sureties. And one specific amount paid by one particular surety is appropriated to the debt in question, debt due in question. And therefore, the other also needs to be treated for servicing the debt itself. And if that be done, the debt due pro tanto gets reduced, diminished, which eventually would enable the appellant, if at all he has to make a pre-deposit of the lesser amount than what otherwise would be. Okay. These are the 3 points. Please. Okay. Yes, sir. Sorry.
No.
About to start. Yes.
My lord, the first question I will take, my lord.
Conduct of the petitioner.
Before I come to conduct,
Yes.
I think it is important for me to clarify whether this appeal is debt specific or whether it is cause specific. Would your lordship kindly look at section 13 of the Act, my lord? Section 13(4). Please look at 17 and then 13(4) for a minute.
70.
17, application against measures to recover secured debt. Any person, including borrower, aggrieved by any of the measures, so it's used in plural, referred to in subsection 4 of section 13, may, taken by the secured creditor or his authorized officer, may make an application along with such fees as may be prescribed to the debt recovery tribunal. The measures are mentioned in 13(4). Now, please look at 13(4), my lord. In case the borrower fails to discharge his liability in full within the period specified in subsection 2, sorry. I'm reading subsection 4 of section 13.
Correct.
In case the borrower fails to discharge his liability in full within the period specified in subsection 2, the secured creditor may take recourse to one or more of the following measures. So there are a multiple series of measures that are available. For each of those measures, there is a cause that is available to the borrower to approach the DRT. Now let us look at a situation where, in the facts of the present case, the possession notice, your lordship may kindly take the dates. Possession notice was issued on 12/2/2020. My lord, the possession notice under section 13(4) is dated 12/2/2020. He approaches the DRT in SA 95 of 2020.
12/2/2020.
12/2/2020.
SA
95 of 2020, which is renumbered as TSA 11 of 2022.
CSA.
TSA 11 of 2022.
TSA.
Transfer securitization application, because it's
From Bangalore to Chennai, it got transferred. So it's a
11 of 22.
11 of 2022.
Yes.
Now, my lord, when even as this is going on, my lord, the sale notice is issued on 26/7/2022. Sale notice.
That is under 13(4). Possession notice and sale notice are same. Is it true?
It's also under 13(4).
the power emanates from 13(4) statutorily.
My lord, this is read with rule 9(1) of the enforcement rules.
13(4) is read with, that possession is read with?
Possession is 8(1). 8(1). This is read with 9(2) of the rules.
Rule 9?
9(1).
Earlier one is 8(1), this is 9(1).
8(2).
8(2).
So the sale notice is dated 26/7/22, fixing the auction on 10/8/22.
Yes. 10/8/22.
My lord, the date of auction is 19/8/22.
19/8/22.
This is challenged in CH-07 of 23.
Yes.
Now, if your lordship looks at the DRT order, the DRT order that was handed out by my friend
Yes.
today. This is the order passed on 9/11/2023.
Correct.
Which is the order that is impugned before the appellate tribunal.
TSA 11 of 2022 order.
And 7 of 2023.
7 club ಹಾಕೊಂಡು.
But separate order ಮಾಡಿದ್ದಾರೆ.
Club common order
ಅಲ್ಲ, ಅದಕ್ಕೆ internal page 23 ನೋಡಿ.
23.
TSA 11 of 2022 stands dismissed. Parties to bear their own cost. Copy of the order be communicated, etc. Then 7 of 2023 is dealt with.
ಒಂದೇ ಆರ್ಡರ್ ನಲ್ಲಿ ಎರಡು ಭಾಗ ಮಾಡಿದ್ದಾರೆ, ಸೆಪರೇಟ್ಲಿ ಟ್ರೀಟ್ ಮಾಡಿದ್ದಾರೆ.
For all practical purposes, it is two orders. So 11 of 2022 is dismissed. Then 7 of 2023 is
separately treated.
Now against 11 of 2022, against the possession notice, he goes to DRAT. But against 7 of 2023, please have a look at, my lord. What happens to 7 of 2023? Please come to the last page of that order. At page 42. My lord, please look at 41. Paragraph 29
is dismissed.
29.3. In view of the above rulings and after considering the grounds urged in essay, and though the earlier proceeding was not prosecuted,
Does not find merits in this one. And
does not find merit so and so, as answered so and so, entertain extending the benefit of section 14, petition lacks merit. So on merits and on limitation, this order is dismissed. Against 11 of 22, he goes to DRAT. Against this order on 7 of 23, he comes to this court. Please have a look at the order that is, he approaches this court, my lord. At page 554.
Correct. What falls from that?
No, it is dismissed, so he goes back to DRAT. So it's separate. Your lordship sees first possession notice is issued.
Your version is the structure of the language.
I'm only saying that each cause is different.
Therefore, different appeals.
That's
so for each of the appeals, he has to make the separate pre-deposit your content. Suppose if 10 appeals are filed and amount due is 7.5 lakh, he should pay 75 lakhs. Is your contention?
No, I mean,
actually,
your lordship sees it's each event is separate.
No,
your lordship sees, for instance, on possession notice, there is an order that is passed.
Correct. No, there are separate. No, we don't agree with his view that there are no separate appeals at all. I am with you now. We are with you now. Arguably, for argument's sake, there is plurality of appeals. You mean to say there should be plurality of pre-deposits?
How? That is how, my lord, on a general principle, if your lordship asks me, it may appear to be so, but under 18, you have, for each appeal, you have to file a separate pre-deposit. That's why they have given a minimum of 25% and a maximum of 50% as far as 18 is concerned.
Suppose 1 crore rupees debt. There are 10 sureties, 1 borrower, total 9 sureties and 1 borrower. 1 borrower can file at least 3 appeals going by section 13, which you have read now. So 30 appeals, 30 crore rupees minus the discount, whatever discount the tribunal will give, that finds logic and reason. There is a presumption which Broom's legal maxim says the law should be interpreted as being logical and just. in such an event, what you say is that's the prescription of Parliament. Your answer would be, that is the prescription of the Parliament. Unless challenge is led to that, you should go by the law is your worship. Any other reply? For
No,
this?
I'm only taking this a step further to impress upon your lordships. My lord, possession notice is, there's an order, there's a challenge to the possession notice.
Correct.
The possession notice is upheld, and there is an appeal that is filed to the tribunal challenging the possession notice. Now, even as this is going on, the sale takes place. Now, the sale, he may challenge the sale, he may not challenge the sale, or he may say that the sale is an event subsequent to the possession notice, and if I succeed on challenge to the possession notice, I don't need to challenge the sale at all.
Consequential.
Consequential. Therefore, my lord, your lordship says, if he chooses not to do it, the cause remains only with the possession notice, the challenge to the cause relating to the possession notice. Here, separate orders are passed, though in the same order.
Where is your answer to our question? You are only repeating other things. Where
No,
is
but
your answer to our question?
My lord,
Our question is so specific and pointed. We have given an example now to make it extremely unjust. We have given, again we are saying, 9 sureties. One principal borrower, 9 sureties. 3 appeals can be maintained going by the structure and action of section 13. So there will be 30. So each of the appeals should be accompanied by pre-deposit of 1 crore rupees minus discretionary deduction. It will be 75. That is, even if it is 75, 7.5 crore, that would be offending the sense of logic to say the same. In right from 1702, if we read The Machinery of Justice by Jackson, the right of appeal in any colonial country has to be just and non-onerous. There is jurisprudential support for this. That is the reason why they struck down 17, which related to original proceeding. They wanted to overcome the lacuna which the apex court found in Mardia and had struck down 17 in a wholesale way by diluting the requirement of any deposit itself. Appeal, they said, for appeal, public money is involved. They have used the word debt due in both the sections. Debt due should be the limit. Appears that way. But you are only giving you some hint so that you can come out with your answer also. In other words, plurality of the appeal is irrelevant. The amount which is called as debt due under 2HA is relevant, is pith and substance of his submission. Law has to be, there is a presumption. Law has to be interpreted with abundant common sense, sense of justness, sense of reason. If we agree with you, then so many appeals we have to dismiss because you have not complied with pre-deposit. That will be extremely onerous. In the sense, even Hammurabi would not have coined that section that way.
In the facts of this case, what has been granted, ordered by the tribunal is 25% only, my lord. Minimum only has been given. It can't be any less than this is my submission to your lordships.
Anything new?
Yeah. Your lordship may kindly take this, he comes to this court, my lord, at page 554.
Learned senior advocate appearing for the, you are for the bank?
No, I'm for the auction purchase.
Auction purchaser submits that the requirement of making pre-deposit is number of appeal specific and not
cause specific.
cause Next point.
Next point, my lord, please have a look at the order that I have just handed over to your lordships, my lord, of the learned single judge.
Yes.
Please look at internal page 16 of that order.
16.
Paragraph 13.
Yes.
The allegation is that the property is being sold at inadequately low price and the reserve price has gone on decreasing from sale to sale. The reserve price has reduced are as follows. Lord, on 15 to 21, it was so much, it comes down.
Science.
The contention that the valuation report was taken only once on so-and-so and prior auction notice, there was no valuation report taken. It is this that the learned senior counsel would submit that has become the foundation or maintainability of the petition at the hands of this court. The objection to the said contention is that the sale has taken place on 19/8/22 and the buyer is one Anushka Constructions Private Limited. The first respondent bank made several attempts prior to the sale to auction the property. The auction sales were conducted on so-and-so dates. In all these attempts of sale, there were no bidders. It is only in the sale that was conducted on 19/8/22, the bank has been successful in finding a bidder and the auction became successful after multiple failed attempts. It is right that the standard practice is reduction of 10% of the reserve price if there is no bidder who comes forward to a particular reserve price. Prima facie, I find no statutory aberration committed by the bank in reduction of the reserve price. The bank not having found a buyer on several attempts, finds one in the last attempt who has also deposited the amount that is required, and a submission is made that he is ready and willing to deposit the entire amount. Be those submissions as they may be, what requires to be noticed is the conduct of the petitioner.
Sir, why are you reading this to articulate the point first?
But
In support of what point you want to
on support of the point regarding conduct of the petitioner.
Okay.
The petitioner has presented the subject writ petition on 23/8/21. The matter was not moved for listing. For almost a year, the matter was at the stage of clearing office objections. At the same time, the petitioner has knocked on the doors of the Debt Recovery Tribunal by filing several petitions challenging several sale notices in relation to collateral security. None of those facts have been divulged in the petition. When those proceedings were pending consideration before DRT, an application is moved seeking stay of the auction proceedings to be held on so-and-so. The petitioner has not disclosed the several proceedings filed before DRT. Even in the present sale notice, the petitioner has preferred an application before DRT, and the learned senior counsel appearing from the bank would submit that the copy of the petition has been served for it having been filed. None of these facts are placed on record by the petitioner. On this solitary ground that the petitioner has not divulged several proceedings before the DRT, calling in question several sale notices, and those proceedings being pending before the DRT alone would become enough circumstance to deny the entertainment of the petition. The intention of the petitioners to be to dodge the issue as long as possible and as far as possible. Therefore, on this solitary ground of non-divulgence of aforesaid facts, I decline to entertain the petition. The petitioner is anyway before the DRT in several proceedings. The grounds that are urged in this petition can always be urged before the DRT, and DRT is in jurisdiction to consider all these grounds. Now, my lord, your lordship may take your lordship's division bench judgment.
Learned counsel, senior advocate appearing for the auction buyer, draws attention of the court to the contents of paragraphs 13 and 14 of Justice Nagprasanna's judgment to contend that the conduct of the petitioner borrower does not entitle him to the discretionary relief at the hands of this court.
EIR 2019, Karnataka. EIR
2019.
19, Karnataka, paragraph 32.
No, I have
To
copies.
Vijay Mallya, where on conduct we have said something. But
I have.
in support of this, he draws attention of the court to the coordinate bench decision in Dr. Vijay Mallya versus State Bank of India, paragraph 32. Yes,
Then, my lord, please,
para 32. Vijay Mallya, para 32. Yes.
then in the list of judgments, my lord, that has been given by my friend, I had also got it. There's one judgment at page 149, Siddharth Neelkant Paper Industries.
For the proposition,
For the proposition, what is debt due?
Page,
Paragraph 34 and 35.
page.
It starts at 149 at 158.
You're right. Siddha Nilkant. That one? Siddha Nilkant paper.
Siddha Nilkant Paper Industries. I think that's the two statement. 2011. May I read, my lord?
Yes, sir.
As per section 18 of the SARFACI Act,
Paragraph
34 at page 158.
on debt.
Yes. In fact, if your lordship looks at 157 previous page, they have in paragraph 32, they have referred to.
PHA.
Yes, HA, then also 2G of the,
Correct.
exactly what your lordships are saying.
Correct. Yes. It's an inclusive definition.
It's an inclusive definition. Debt due means debt plus interest. And for that, your
Always.
And for that, your lordship may look at the writ petition, page 107. 103 is the statement of objections that is filed by the bank. Page 103 is the bank counter affidavit, my lord. Annexure D.
In the appeal memo.
Yes, appeal memo. Just after the impugned order.
Page number?
Page number 103.
You're right.
Page number 103, counter affidavit of respondent number 1 bank. Otherly 107, para 13.
Against the above background, it is related to the plaintiff has not made out even a
Has not made out a brave prima facie case, so and so. Respondent has received 113 crores pursuant to the sale by the liquidator of the respondent under the provisions so and so. And after appropriation into loan account, a sum of rupees 82 crores 58 lakhs so and so as of, although there's a typographical error, it should actually be 34/2024. Is still due and outstanding. Now, this is the figure that is taken into account by the tribunal. This includes the sale consideration paid by the auction purchaser. Top of page 108, my lord.
After the appropriation into the loan account, a sum of rupees 82 crore 58 lakh. No, 825 crore.
82 crores 58 lakhs
87,541. This amount is due.
This is the amount that is due. Yes. As on 34/2024.
That is 34/2024. 14.
34/2024.
But it should be 24. It should be.
Yes.
You're right. Yes. Whether other surety has also made the payment.
Para
It's
12.
right.
Para 12
of the same affidavit.
Para 12.
Please.
Whatever payment, do you agree? Whatever payment is made, that should be given deduction too, while adjudging debt due. Perhaps yes.
Yeah, that has been taken into consideration and thereafter only 82 crores they say, my lord.
They have arrived at.
Your lordship may look at page 86, my lord. Of
What was the amount due on particular date before these payments were made? When did you quantify the amount due?
Pardon,
The amount due. When did you quantify? Before these two payments were made? Which date?
on 34/24, my lord. 34/24.
2024.
Yes.
What was the amount due? That 82 crore, etc. you said, no?
That is
That's what
referred in
the-
page 72 of the order, my lord. Page 72 of the order,
72. No, you were reading this
para 108.
108.
Yes, 100.
That's the correct figure.
Yes, that's the correct figure. That is reflected in the impugned order also.
One second. 82, 58, 87,
541.
541. This was as on
34.
30 April 2024.
Yes.
So 20% wrongly written. When the amounts were paid by the sureties, which date? Obviously, subsequently,
Please, my lord, subsequent to
which is the date?
my lords,
Two sureties.
two sureties.
One surety paid 100 and
My lords, the borrower
No,
paid
no, no.
113 crores
borrower himself paid. When?
through the liquidator.
When?
January 23, I think.
Then he is right. That cannot be, that's already taken note of. That has
That
been given
113
discount.
is taken note of.
What about the other surety?
Please, my lords, that is found in para 12.
We are asking on which date, how much money is paid, what we should do with the paragraphs.
No, just give me the date.
We want the figures.
Please,
August 2019, 25 crores.
30. My lords, it was paid on 30th August 2519.
Then that also should have been subsumed in this only.
Everything is
Lord.
subsumed, my lord. Your lordship,
para-
look at page 86, my lord. 72 and 86
Of appeal memo,
of the impugned order in the appeal memo. Your lordship is right.
page number
72.
72.
The order starts at 63. Please have a look at 72.
You are right. The payment of the 43.37 made by Messrs. So and so were not sufficient to satisfy the debt due. As on 2024, perhaps it is.
Yes.
24, there was still an outstanding of 82 crore, etc. After giving credit to the aforesaid amount.
After giving credit to the aforesaid amounts.
That's all.
Which para is it?
And in fact, that is, my lord.
That
found-
page 72.
Please
Your
look
appeal
at-
memo.
Please look at page 83, para 25. Page 83, para 25. It is stated in the counter affidavit, sorry.
Learned senior advocate draws attention of the court to page 72. The internal page 10 of the order of the DRT, tane?
DR80.
DRAT. To the effect that the amount repaid by the principal the petitioner herein has been given credit to, and only thereafter the outstanding amount is quantified at rupees 82, 58, 87, 541. Which is that you said in 2019,
Please, my lords.
that has not been given credit to.
No, my lords. Your lordship may please see the counter affidavit.
My lord, please, wait 1 minute.
One second.
Lordship may just see page 83, para 25 of the same impugned order. my lord.
83.
Para 25. It is stated in the counter affidavit filed by the first.
Sum of 43.47 crores had been adjusted towards the term loan due. It also stated that sum of 113 crores received from OAL. Proceedings from said Bangalore was released to the.
Thus, it is
corresponding
clear that
bank.
towards the loan amount, a sum of 157, that is 113 plus 43 was recovered. As per the counter affidavit, the amount due as on so-and-so was so-and-so. It appears that has been apportioned to the loan.
Appears that aforesaid amount had been apportioned towards, and appropriated.
Yes.
Towards the loan amount. ಅದಕ್ಕೆ ನಿಮಗೆ 82 crore 52,87,541. As on which date you quantified that?
34
much subsequent to that.
34/2024.
So that is much subsequent to 2019.
All
and,
the other
earlier
payments are
ones.
taken into account.
Appears that way.
In the
That's why your lordship may now come to page 86. In the case beforehand, The challenge was against the possession notice dated 12/2/2020 and sale notice dated 26/7/22.
The separate
Each-
cause of action, etc.
So, and then he says, deposit 25% of 8258, that is 20 crores in each of the appeals.
That is it.
Therefore, he says 25 is the least that could be asked for.
Yes.
And in any event, my lord, third party, I have paid 82 crores as the auction purchaser, I have paid 82. From 2020, he is dragging on the matter. Nothing he has paid. After possession notice, no money is paid at all. It's just a shot at somehow. Anything?
Lord, that counter affidavit, if your lordship will please see para 12,
Of their affidavit,
their counter affidavit before the debts recovery appellate tribunal,
page number.
Lord, page 107.
Just 1 minute. My lord, just
Is
one
it-
more, your lordships was saying, sorry,
Please, sir.
this is a statutory right of appeal.
Correct.
ಅದನ್ನ ನಾವು ಇವ್ರಿಗೆ ಹಾಗೆ ಕಳಿಸ್ಬಿಡೋಕ್ಕಾಗುತ್ತಾ ಅಂತ ತಾವು ಕೇಳ್ತಾ ಇದ್ರಿ. ಅದು ಒಂದು ಮನಸ್ಸಲ್ಲಿ ಬರೋದು
Natural.
natural thing that has been considered by the Honorable Supreme Court, my lord, while considering this section 18.
Correct. Such natural things court should not say. Court should go by the terms of the legislation, because right from 1707.
I don't know how to say it in a manner that would not
No, what
displease
you
the
said is
court.
perfectly all
That
right.
would not displease the court.
No, you have understood. If the legislature, if the legislature creates the right of appeal, it has power to create it with condition. If conditions are prescribed,
Correct.
unless those conditions are complied with, no right of appeal becomes go-ahead. That's the law.
Correct.
That's what we have reiterated in Vijay Malya's also. Which is the paragraph you want us to read?
Please look at paragraph 7 and 8. In paragraph 6, my lord, they extract section 18. Section 18(1) confers a statutory right on a person aggrieved by any order of the DRT under section 17 to prefer. The right conferred is subject to the condition laid down in the second proviso.
Unless the borrower makes such appellate tribunal signs, same thing.
No
We have
absolute-
reiterated it.
Then 8, it is well settled that statute confers a right while granting legislature can impose conditions.
That's what.
Exactly what fell from my lord's.
So long as the conditions are not so onerous.
No, unless you challenge the section itself.
Yes, the vires of the section itself.
Which
We
I-
have not challenged that. Therefore, we have to take there is a very strong presumption that every legislative instrument, if not a subordinate legislation, is valid and constitutional and has full efficacy. That R.K. Ramakrishna Dalmia versus Justice Tendulkar, where Justice P.K. Mukherjee said that it is like this only. Very strong presumption. In fact, Shirwai in 4th edition makes a whole lot of that note in one separate paragraph. Now, page, he dedicates 2 pages on that. Therefore, unless you challenge, that is one thing. But in the guise of interpretation, to do justice, this is what Lord Denning says in his first book, Road to Justice. However draconian law you may give me, I will take milk from that by my own interpretation. That we have accepted by the appeals court, but that's not the case now. Appears that they have given discount that money. Now, the only point remains would be, according to him, the deposit is cost specific. According to you, the deposit is debt due specific. These are the things.
On that,
Last point, your lordships, there's that Madras High Court judgment, division bench judgment. There what happened was, possession notice was issued. No stay was granted, appeal was filed. Both father and son filed appeal against the same possession notice.
But 2 appeals.
2 appeals, I know, but it's the same against the same thing. There were no 2 separate causes of action, my lord.
That defeats your contention.
No,
Why?
because here
If it
it's
is
a
cost specific.
No, no.
there we-
possession notice, sale notice. Illi erediде.
Correct. We understood that. Point 2.
It's the same order.
To say is whether same appellant or different appellant pales into insignificance in the linguistic structure of section 18 is your submission. Understood?
Leave it.
I'm appealing for the parish. In furtherance to the submissions made by Lord Senior Counsel, my lord, the prior, my lord, they sought in the prayer number 2, my lord, is to direct the said appeals and be heard on without any pre-deposit, my lord. My contention is while the fact of whether my submission, my lord, the discretion under 18 is already been exercised by reducing it by 50 to 25. Their contention, it cannot be 225, it has to be 125, be that as it may. Now, the prayer says
All
that.
right, prayer, we are not, that, it's not prayers are always
Only to
there.
that fact.
Litigants, any litigant will ask for moon only.
Please, sir, only to that effect, my lord, my the only judgment I would like to rely on is to the fact that
For the
as far as the mandatory requirement is concerned, my lord, even in this case, sir,
What is the proposition?
no, the proposition is to the fact that when there is a mandatory requirement, below 25%, it cannot be exercised. Even if the court assumes, I mean.
No, he is not on that.
My lord, I am only on the prayer that it was been, sir.
Anyway, what is argued, he is not on that. Please give back those rulings. We don't multiply rulings here. We'll read everything if you give. That's in our private time, but it's a public time where you have to be very, very responsible in citing the
Because in
decision.
this case, my lord, also, it was taken into consideration after an amount being deposited. Pursuant to that, what was the outstanding, the court had reduced the amount, to which the court said below 25, it cannot go.
All right.
Page 107, para 12, it
What
not
for?
appear to be included, the 43 crore.
Yes.
Their contention in para 12 in their counter affidavit before the Debts Recovery Appellate Tribunal. It is submitted that respondent number 1 has fully adhered to the provisions of the law in dealing with secured property. As far as payment of rupees 43.47 crore is concerned, it is submitted that the said amount was paid to the respondent number 1 under settlement, and the amounts were appropriated against term loan 2 facility. This is term loan 1 facility, not term loan 2. With the consent stroke knowledge of respondent number 2 and Messrs. Lingamaneni developers who had made the payment into bracket unconnected to the present surface proceedings stroke demand notice dated 11/6/2019.
No, there were multiple loans.
Please, my lords. The
The
sureties were only
surety
for
sent that.
term loan 1.
No, did he say that it is term loan 1?
Section 13(2) notice of the bank itself
Saying,
shows me and this co-surety as the surety for the same loan.
that amount is not given discount.
They
That
say
is given discount in another loan.
that is given discount in another loan.
Now, what is the bank's prerogative?
Not
Ordinarily,
Please.
under law of contract, where the debtor makes the repayment,
please.
it is open to the creditor to appropriate to one of the loans which he is holding,
Please.
or to the principal of one of the loans or all of the loans, or to the interest of the loan. That's the law. Unless the statute otherwise says.
Lord, I bow down to what falls from your lordships.
No, not me. The Lord Atkins said long ago, I think in 1930s, something like that.
May I provide, my lords, 2 points of distinction. One, in this case, he is not the borrower, he is a guarantor. His guarantee therefore is bound to the loan. Second, my lords, this 13(2) notice is a statutory exercise of power. Under section 13(2), he has issued a notice where he has taken a firm and categorical stance that this surety is in respect of this and this loan only. He takes that stance in 13(2) notice. In his counter affidavit at para 12, he
But
says,
that goes to treating the matter a little on merit side.
not all I am submitting is the submissions that were advanced now are contrary to the submissions in para 12
12 of affidavit,
of the very same affidavit of which the
Where is
learned
that?
senior
Page
read para 13,
page number.
page number 107. Let my lord the bank make a categorical statement because learned senior is appearing for the auction purchaser. Let the bank make a categorical statement that it is included. It's contrary to para 12. The words in the bracket, my lords, unconnected to the present surface proceedings, stroke demand notice.
What do you say, brother?
Earlier to the objections being followed, the party is bound by the guarantee being given. The guarantee clauses have been taken into consideration by the DRAT.
But you have mentioned his name also in your 13 notice.
Please, my contention is that as far as the corporate guarantee is concerned, it talks about any amount due.
Correct.
Hence, the appropriation was towards all accounts.
No, it is specific because notice you have given under 13.
Please,
You have mentioned his name also.
I
If
agree.
that is so, where the surety says that this amount is to be paid to on account of X loan,
In the corporate.
then the X loan only.
Lord, kindly have
And term loan 2 was never disbursed.
Paragraph 16 onwards of the impugn order, my lord, the whole subject matter does not relate to the term loan 2 at all. The terms of the contract is that it spills over to the other loans availed by the borrower.
Where is that?
My lord, the impugn order
Show that,
recognizes
show
that. Page 7.
No, in your, let us go to your notice. Your notice under 13.
Annexure X at page 241.
Two 41.
Please, my lords. It is issued to two persons. Your lordship's petitioner is at serial number 1, the co-surety is at serial number 2. One is the petitioner, my lords. Serial number 2 is the co-surety referred to in para 13 of his affidavit.
Yes.
And if your lordship please sees page 247, the annexure, it becomes crystal clear, which is an annexure to the very same notice.
247.
Please, my lords.
Term loan.
Term loan is 150 crores.
Correct.
It is this term loan which is the subject matter of the notice.
Not a short-term loan at all.
No, my lords. In fact, in para 13, they mentioned term loan number 2, that sum was never disbursed even according to them.
Where is that? To show that they had never dispersed that amount?
Page 337, my lords. Their objections in the earlier writ petition at page 337, para 30. It starts at annexure AI, my lords. At page 329, the relevant portion is 337. Para 30.
37. Volume 2.
Lords, in the
Volume 2.
of the writ petition papers. I think 2 volumes. I'm so sorry.
337.
Annexure AI, my lord, at page 329, running page 329.
329, huh?
Please, my lords. Statement of objections filed
Correct.
in this in one of the writ petitions. The relevant portion is at para 30, page 337.
Sir. What they have said?
Lords, they say it is further submitted that during the meeting between respondent number 1 and 2 on December so and so, a sanction of additional term loan of rupees 20 crore was deliberated. Thereafter, respondent number 1 sanctioned an additional facility of rupees 20 crore and the sanction letter dated January 14, 2015 for rupees 20 crore was also issued by respondent number 2, TL2 sanction letter. However, it is pertinent to note that respondent number 2 did not avail the loan facility and did not come forward to create the security as provided under TL2 sanction letter or execute the loan agreement in
Yes,
this.
brother.
Subsequently, my lord, in the same matter, we have filed an affidavit at page 385, wherein we have stated the summary of dues, which says that short DL to
385.
TL 1 and 3 were disbursement. My lord, but
2 was not dispersed at all.
but the fact here, my lord, whether it can be considered now, it's a question of merit. Today, we are only before to the fact of pre-deposit. Now, this factor, my lord, is so my contention is that under the guarantee, it says any dues which I am entitled to recover. Now, for that, my lord, on merits, I'll have to satisfy before the DR rate.
No,
But
not late.
I,
This is a thing which can be ascertained. From the record, no oral evidence is required.
please,
We have to ascertain it from the records only.
please.
It is not some Kallegowda, Mallegowda's farm loan. It is in crores. Therefore, you have to show here. Your notice is term loan 1 specific.
My contention is that, my lord, under the guarantee, it talks about any other due made by the borrower. Hence, my right is still there, as far as the other loans also are concerned. And the learned DR judgment recognizes that, my lord.
That's the reason he is here.
Please.
One of the contentions is that only.
In fact, my lord, the honorable DRAT proceeds on the basis that this is included. And that was also, my lords, the argument on behalf of the auction purchaser.
All.
Please.
Heard,
So,
result
Just one.
judgment
just
tomorrow.
One submission.
Yes, sir.
Lord, please have a look at Siddha Neelkant again.
Section?
Siddha Neelkant judgment, my lord.
Ah.
It starts at 149, Division Bench of the Honorable Supreme Court. The money that is paid by the auction purchaser cannot be taken into account for
Correct.
calculating money
That is
due.
not taken into
No,
account.
1 minute.
Correct.
Please have a look at 159.
No, I agree with you.
No, just have a look at it. my lord.
159.
159, para 35. If the words used, not fifth line of paragraph 35.
Yes.
If the words used.
Borrower has to deposit.
If the second proviso so and so, our borrower has, it is not appreciable how the amount deposited by the auction
That's
purchase
true.
on purchase can be adjusted or
We
approved.
have held that way.
ಆಯ್ತು ಈಗ ನೋಡಿ ಈಗ ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ನೋಡಿ ಪ್ಯಾರಾಗ್ರಾಫ್ 27 ಆಫ್ ದಿ ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ನೋಡಿ ಅದು ವಜಾ ಮಾಡಿದ್ದಾರೆ ಪೇಜ್ 84
It's 84.
ಪ್ಯಾರಾ 28 page 84, para 28. Here in this case, the amount deposited by the auction purchaser by way of sale is not sought to be considered by the petitioner appellant for calculating pre-deposit, but the amount realized by the sale of the property by the official liquidator is sought to be considered. There is no statement of account produced by the bank as to the amount due along with interest on. We have the outstanding figure on so-and-so of 8258 towards debt after apportioning the amount realized, etc. Therefore, ಈ 82 ಗೆ ನೀವು 80 ಗೆ ಆಡ್ ಮಾಡಿದ್ರೆ ನಂದ್ರಲ್ಲಿ 160 ಆಗತ್ತೆ 160 ಮೇಲೆ 50% ಆಗತ್ತೆ ಮತ್ತೆ ಇನ್ನೂ ಹೆಚ್ಚಿಗೆ ಆಗತ್ತೆ ಅವ್ರಿಗೆ. My 82 which I have paid as auction purchaser is not a part of this 82.
It cannot be.
Not with utmost respect, this is creative because
It
para 28 says not sought.
ಅಲ್ಲ
It cannot be.
ಅಲ್ಲ ಬ್ಯಾಂಕ್
Bank say.
ಬ್ಯಾಂಕ್ ಅಲ್ಲ ಬ್ಯಾಂಕ್ನವ್ರು ಏನ್ ಹೇಳಿದಾರೋ ಬ್ಯಾಂಕ್ has calculated the balance due. They have not taken into account.
Bank should have furnished the statement of account to the DRA.
ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳೋದು
saying
ಬ್ಯಾಂಕ್ನವ್ರು
that
ಮಾಡಿಲ್ಲ.
so much amount is due. They cannot take the contention to resist the appeal without their discharging their own duty. The courts of Tannan on banking law says it is the duty of the lending bank to tell the borrower what is the amount due. It's so much important. That duty they have not done. On that, how can you press that into service
I'm only trying to point out
to help him?
he has already got benefit of that 80 which is not included into that 82.
This is completely contrary to record. The bank
Anyway,
never took this.
He is showing something which appears to be apparently some staring at us. That's what the learned senior advocate is saying. Anyway, heard judgment tomorrow.
Great.
But lot of law I learned from all of you. I learned at least, perhaps my brother also. may concur.
Thanks to your lordship's
That.
suggestion, Lord, I got a copy of.
But one thing, Manu, you come with so much preparation. We have seen you in tobacco matter, we have seen you in other Vijay Mallya matter and such other matters, where we come with a lot of preparation. You are a youngster. We can't praise a senior advocate is another thing, but youngster, we should. Yes.
Great. So
Sorry.
appearing for petitioner.
Yes,
Just to refresh my lord's memory.
not necessary. My memory generally does not fade away.
Grateful.
Generally, it does not fade away.
My lord has directed the parties to be
Be
present.
present here.
Yes, they are
What are the
present.
repairs? Ask your client whether he is
That's-
ready
I
to
have
do
done
it,
some
because all
homework.
his appeals have been negatived by the apex court.
My lord,
Where is your client? Ask him to come here.
I have done some homework. What are the payment due from the complainant? And what are the works which are pending? What are the works which we have?
I
ourselves-
said memory does not fade away.
Correct.
It's a overstatement. But anyway, it's within the short period, it does not fade away.
Correct, correct.
Uh,
Because my lords will have a lot of matters, that is the reason why.
Yeah, I understood. Understood. To save money. I remember every word you uttered
Great,
other
sir.
day yourself. You, yes.
My lords, I have done some tables so that my lords, I have served the copy to other side also.
All right.
Copy receipts. There are total 25 defects to be removed.
All right. ಮಾಡೋಣ. ನೋಡಿ, ಒಂದ್ ಹೇಳ್ತೀನಿ.
Yes, sir.
ಕೋರ್ಟ್ ಮುಂದ್ಗಡೆ ಇದು ಒಂದು ದೇವಸ್ಥಾನ ಅಂತ
Correct.
ತಿಳ್ಕೊಬೇಕು. ಸತ್ಯವಾಗಿ ಹಂಗೆ ತಿಳ್ಕೊಬೇಕು.
Correct.
ನಾವು ಪೂಜಾರಿಗಳು, ದೇವರಲ್ಲ.
Yes.
ಆಯ್ತಾ? ನೀವು ಹೇಳುವಂತ ನೀವು ಮಾಡುವ ಪ್ರಾರ್ಥನೆಯನ್ನ ಭಗವಂತನಿಗೆ ಮುಟ್ಟಿಸ್ತೇವೆ.
Yes.
ಭಗವಂತ ಏನೋ ಒಂದು ಇನ್ಸ್ಪಿರೇಷನ್ ಕೊಡ್ತಾನೆ, ನಾವು ಜಡ್ಜ್ಮೆಂಟ್ ಬರೀತೀವಿ, ನಿಮ್ ಕೈಯಲ್ಲಿ ಕೊಡ್ತೀವಿ.
Yes.
We are more like big postmen.
Yes.
Okay. Therefore, don't stand on egos.
No.
Egos ಮೇಲೆ ನಿಲ್ಬೇಡಿ.
Yes.
Ego dating has to be done by everybody.
Correct.
Okay. All right.
Finish.
ನಿಮಗೂ ಅಪ್ಲೈ ಆಗ್ತದೆ ಇದು. ಏನ್ ಹೆಸರು ನಿಮ್ದು? ನಿಮ್ಗೆ ಕೇಳೋದು.
He do not.
He does not understand Kannada. Okay. Anyway, you come from Bombay? Bombay. Why can't you settle all these things instead of we writing a judgment rightly or wrongly? Why can't you settle these things? What is that compromise? Compromise means what? You have to implement the order.
We just looked at this. He has to go through the amounts with the.
You willing to,
We are willing to come.
have you completed the order?
Compromise alla, compliance. We are not on compromise. We are on compliance.
Yes.
Are you going to comply or not? Because you have lost the case at the Supreme Court. Therefore, we are telling you. This is only a concession. Otherwise, your lawyer has already argued. This lawyer also to some extent argued other day. Now we have to proceed with the orders. Instead of that, one more opportunity so that the friction is not that good in life. To you also, to those who are standing behind your lawyers,
Yes, I have instructed my claim.
tell them.
Yes, I
Anyway,
have already.
something. See, our Subhashita says, Vinashakale samutpanne ardham tejita panditaha. So go for some compromise. Your section 89 of CPC was enacted long ago in
Yes.
Subhashitas,
Yes, yes.
thousands of years ago.
Correct.
Yes. What is to be done now? ಏನೇನ್ ಮಾಡ್ಬೇಕು? ಏನೇನ್ ಮಾಡೋದಿದೆ?
My lords, I just culled out the tables. Kindly turn to the first page. Defects cured by the respondent. Ourselves, we have cured it. 7 defects which we have already cured it. And expenditure involved which you have mentioned in first table. My lords got it?
11,07,000.
This is expenditure which we have.
What are the bills? Expenditure.
Material.
What was the work you have done? Show that.
Yes, work which is done, which is culled out here.
Tell me.
First table, nodi. Defects cured by the respondent.
Hangandri is very nebulous way of saying things.
Yes.
Defects cured.
My lords, I'll just support material. Just I'll say that this is the defects which is cured by the respondent. Next page, defects
So
which are not
latches and
cured.
locks provided for the door system.
Yes.
Yes, latches, yes, doors.
That material.
ನಮ್ಮದೇ ಅದನ್ನ ಹೇಳ್ಬೇಕು. ಎಷ್ಟು latches, ಎಷ್ಟು doors, ಎಷ್ಟು locks.
Yes, my lords. I'll provide the material, my lords. Kindly turn to next page. Just defects which are not cured. That is 14 in number.
ಏನು?
Next page.
Effective flooring work.
ಇದಲ್ಲ ಇಷ್ಟು 14 ಇದೆ. Next page. Defects which cannot be cured. Next page. Next, compensation awarded and fine amount awarded by the consumer forum. This is also not paid.
20,99,500.
500.
ಏನೋ ಒಂದು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡು
Just-
ಮುಗಿಸ್ಕೊಂಡ್ಬಿಡ್ರಿ.
Just-
Shall we see, he has to come from Bombay. Very often we have to call him. Now, see, do something. Otherwise you will be landing in trouble.
Your Honor, this is a letter
ಏನ್ ಲೆಟರ್ ಅದು?
issued by the owners association.
You have not made it part of the writ petition at all. Now you are giving it as you are giving in coffee shop.
Yes, Your Honor. I have received it in the recent past. And moreover, we have worked so much in this particular defect curing, wherein the various acknowledgement is also available.
My lords, court commissioner was appointed during the consumer
Your Honor.
forum, execution court, everything is done.
These are the photographs of and the bills from the part of respondent, which we have complied. The same may be perused, Your Honor. I have not brought it on record as I'm the subsequent counsel engaged in this.
ಸ್ವಲ್ಪ ನೋಡಿ ಏನು ಆಯ್ತು ಜಸ್ಟ್ ನೋಡಿ ತೊಳಿ ಅದು ಕೊಡಿ ಅಲ್ಲಿ ಈಗ ಎಲ್ಲರೂ ಜಸ್ಟ್ ಸಿಟ್ ಅಂಡರ್ ದ ಶಾಡೋ ಆಫ್ ನಿಯರ್ ಬೈ ಟ್ರೀ ಸಿಟ್ ಅಂಡ್ ವರ್ಕ್ಔಟ್ ಅಂಡ್ ಕಮ್ ಬ್ಯಾಕ್ ಪ್ಲೀಸ್ ಪಾಸ್ ಓವರ್
Great.
ತೊಳಿ ಕುತ್ಕೋಬೇಕು ಎಲ್ಲ ಈಗೋ ಬಿಟ್ಕೊಂಡ್ ಕೊಡ್ಬೇಕು
ಆಯ್ತು.
ಯಾರಾದ್ರೂ ಒಬ್ರ ಎಲ್ಡರ್ ಪರ್ಸನ್ ಅನ್ನು ಕುಡಿಸ್ಕೊಳ್ಳಿ ನಿಮ್ ಜೊತೆ
ಆಯ್ತು.
ಆದಿತ್ಯ ಕ್ಯಾನ್ ಯು ಹೆಲ್ಪ್ we'll ask Aditya to
Great.
mediate between you.
Grateful, great.
Okay?
Great.
All right. Thereafter, we will see what orders can be passed. Kindly go and see what can be done.
Yes.
Yes, yes. Do you agree with Aditya's appointment for
Definitely.
mediating between you without prejudice to contention?
No, definitely.
Both the sides volunteer to have the services of Mr. Aditya Vikram Bhatt, learned AGA, as the middleman to, as the mediator of the dispute in question, without prejudice to their contentions in the matter, in the event the mediation fails. All right. ಏನ್ ನೋಡಿ ಅವ್ರ ಫೀ ಏನೇನ್ ಕೊಟ್ಕೋಬೇಕಲ್ಲ ಪುಸ್ತಕ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅವ್ರಿಗೆ ಕೆಲಸ ಇರ್ತದೆ.
Grateful, great.
Mediator can fix his fees for the services. All right. ಎಷ್ಟು ದಿವಸ ಬೇಕಾಗ್ತದೆ
If they provide me a copy of the. everything
ಅವರಿಗೆ
I provide.
ಗಿವ್ ಕಾಪೀಸ್ ನಿಮ್ ಕಾಪಿ
Everything.
ಎಲ್ಲ ಕೊಡಿ. ಇವತ್ತು ಫಸ್ಟ್ ಸಿಟ್ಟಿಂಗ್ ಮಾಡಿ ಒಂದ್ ಕಡೆ ಕುತ್ಕೊಂಡು ದೆನ್ ಯು ಜಸ್ಟ್ ಮೀಡಿಯೇಟ್ ವಾಟ್ ಕ್ಯಾನ್ ಬಿ ಡನ್. ಆಲ್ ರೈಟ್.
I'll have a separate sitting with each of the
ಹೌದು
parties.
ಮೊದಲಿಗೆ
Let's call them for a joint.
ಸಪರೇಟ್ ಮಾಡಿಕೊಂಡು ನಂತರ ಜಾಯಿಂಟ್ ಸಿಟ್ಟಿಂಗ್ ಮಾಡಿಕೊಂಡಾಗ
Great.
Mr. Aditya agrees to the proposal, which is appreciable. All right, a copy of this order be made available to the mediator and to the learned advocates appearing for the parties. Call this matter next week. All right. Ask them, will it be convenient to you?
Not next week, Your
Ha,
Honor.
week after next.
Yes.
Very well. But something should happen.
Yes, yes.
Something should happen. Al Melgade, matter having been heard at length. Is heard at length first. All right.
Great.
Call this matter, which date you want? Tell one date. You don't call your client again and again from Bombay. Everything should happen in 1 or 2 sittings.
Much of.
All right.
Much
All right. You also advise your client to be
Please.
bit reasonable.
Yes,
Okay. Merely because they have got some orders. Let them
definitely.
be not this one. Sit and talk to each other first.
Grateful.
All right. I'll copy, register to share a copy of this order with the learned mediator. So it's. Okay.
Grateful. Obliged.
Which date you want?
Any date between
ಯಾವ್ದ್ರೊಂದು ಹೇಳಿ. Whichever date you
Tuesday
want.
and Friday, any date.
Ah.
Tuesday and Friday, between Tuesday and Friday.
For you also something you have to do.
Friday, week after next Friday.
Week after next, other one date. Good. 13th of February. All right.
Great.
Now have first sitting today.
Yes, yes.
Okay.
Grateful. Much.
All. 13th of, ask your client whether it will be convenient to him.
On 13th.
13th February, all right.
Yes,
Is it all right?
yes, because they are representing a partnership firm. So another partner is available.
Available.
Yes.
Okay. All
See
right.
to it that.
Do something. Finish off this headache. Okay?
Much.
Okay. All right. Yes. Aparted, heard in part. Okay. Post for further hearing on so it's. Okay.
Your Worship,
Ah,
in
Sammati.
connected matter, delay is already condoned, my lord.
Huh?
In connected matter, delay of 79 days is already condoned in the 18.3, my lord.
18.3.
Arising
Is
out of the
condoned.
common order.
Idರಲ್ಲಿ
Delay is
ಎಷ್ಟಿದೆ?
condoned, my lord.
29 days. ನೋಡಮ್ಮ. Application favored. Yes.
Your Lordship, all these matters are not admitted, my lord. It may be admitted as per the questions of law framed in the each separate appeals, my lord.
ನೋಡಮ್ಮ. We'll admit these things. Come. All right. Appeals are admitted on the following substantial questions of law. ಎಲ್ಲದರಲ್ಲೂ separate ಮಾಡಬೇಕು. Call along with each.
Still number 20 is also conducted, same as 23. 23, my lord.
23.
Yes, my lord.
To be called along with this.
Yes, my lord.
ನೋಡಮ್ಮ. 23 ನು ಸೇರಿಸ್ಕೋಬೇಕು ಇದಕ್ಕೆ.
28.
28.
28, my lord. I'm sorry, my lord.
23 ಅಲ್ಲ. Yes. ಹಾ. Yes. ಹಾ.
Response.
Ah.
Land
Yes,
of the
Mr.
petitioner was acquired for the Arkavati layout.
Ah.
This honorable court had sent it to Justice Keshav Narayan committee, and today the order of the committee says my land has to be acquired. Even though there are existing constructions.
Ah.
That order I have assailed before my lords. My submission is now the BDA is undertaking a survey in respect of the scheduled property as well as the other properties. And that survey might have a bearing on this. So I would request
issue,
Manoj
my
to
lord, is
grant me.
what was the state of the land at the time of preliminary notification? Even the inspection report conducted by the BDA at that time, my lord, itself shows there are small sheds there. The property is otherwise empty. Now they say there is a huge amount of buildings and all of that has come up there. And Keshav Narayan committee, Justice Keshav Narayan committee has examined it fully, including, my lord, getting the satellite images of that point in time, and has concluded that there was absolutely nothing in this property, and therefore there is no impediment for it to be acquired. And that is a finding of fact, my lord. Lords may look at the order. It's a complete finding of fact which has been now made.
Yes, Mr. Valla. Good. Ready in the matter? Which date, whichever date you pull down a date. ನಮಗೂ ಸ್ವಲ್ಪ ಬೇರೆ ಬೇರೆ ಕೆಲಸ ಇದೆ ಇವತ್ತು ಅದಕ್ಕೆ. Take some date.
Right, so whatever is convenient to use.
12 or 13. 13th ಆಗ್ಬೋದಾ?
Right.
13th ಆಗ್ಬೋದಾ?
12th.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಒಂದು 11th ಅಲ್ಲಿ ಇದೆ. ಅದೇನಾದ್ರು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಾನು ನಾರ್ಮಲಿ ಹೋಗಲ್ಲ ಇದನ್ನ ಯಾವುದೋ ಒಂದು ಅದ್ ನಾನು ಹಿಂದೆ ಎಲ್ಲ ಮಾಡಿದ್ದೆ ಅದನ್ನ ಅಲ್ಲಿ ಬರಬೇಕು ಅಂತ ಹೇಳಿದ್ರು.
13, 14, whichever. 14th ಯಾವುದು?
14th are some.
Friday.
13th.
All right. 13th. Mr. Valla. Yes. ಒಂದು ಸ್ಮಾಲ್ ನೋಟ್ ಮಾಡ್ಕೊಂಡ್
ಬಂದ್ಬಿಟ್ಟು ಒಂದು ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಎಲ್ಲ ಮಾಡ್ತೀನಿ. ಅಂದ್ರೆ ಒಂದು ನೋಟ್ ಮಾಡಿದ್ವಿ, ಬಟ್ ಅದು ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಸಿನಾಪ್ಸಿಸ್ ತರ ಮಾಡ್ಕೊಡ್ತೀನಿ.
Entry more to continue. Yes. Delay condone
My
ಆಗಿದೆ.
lords,
In
my lords,
assessee's own case.
my
Yes.
lords, I'm appearing on behalf of the respondent assessee. We were served with a copy of the application for condonation of delay today itself. And in the application that accompanies the same, the date of the impugned order has wrongly been mentioned as 31st of July 2023 instead of 15th of December 2022. So my lords, an direction may be given to file a better affidavit in this case.
ಒಂದು ಬೆಟರ್ ಅಫಿಡವಿಟ್ ಹಾಕ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ, ಹಾಕಿ. All right. Better affidavit to be filed by the appellant.
Obliged.
As revenue.
My
Yes.
lords, one other request to the court.
Yeah.
Mr. Aditya Vikram Bhatt's name is reflecting in the cause list. He's no longer part of the firm, and we've already filed NOC Vakalat on his behalf.
ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ?
My lords, Prerna Ponnappa name be reflected.
Srimati so and so appears. And name of Mr. Aditya, name of Aditya Krambat to be deleted. Okay. Yes. All right.
Obliged, my lord.
No. Rajendra.
Yeah, Your Lordship,
Ah,
I am your before Lordship challenging the
ah,
order passed by the DRAT,
ah.
order passed by the DRAT, wherein,
DRE.
yes, it has
Ah.
imposed the condition to comply the section 18(1) of the Act, which is in page number 20, para number 2, page number 20, wherein it has
Pre-deposit. Pre-deposit you have to make.
Yes, my lord. Here, one submission, my lord. When I challenge the auction sale notice, well within a period of 45 days before the single bench of the Honorable Dharwad High Court, Dharwad High Court said, no, you have to alternate remedies available, go to DRT. Against which I preferred appeal before division bench. Division bench also said, no, go to DRT. When I approached DRT, instead of filing application under section 14 of the Limitation Act, because I have time spent before a wrong forum in single division, that should have been taken into consideration. But the DRT said, no, there is a delay of more than 157 days delay is there. We are not going to cut down the delay. Hence, the matter was again approach the DRT.
What is the amount due?
My lordship, one submission, only one submission. My property has been sold. DRT insisted to deposit 2 crore rupees. Against that, again I approached division bench. Division bench remanded back to the DRT to consider. I may read the plain reading of section 18(1). Only one for one moment, madam. Only one for one moment. Only 1 second.
Yes.
I may permit to read my lord. 18(1),
Yes.
what it says.
Read. Morning about 1 dozen time it has been read. Again, read one more time. No issue.
Yes,
No
there.
adjudicator for reading.
Yes, my lord. Yes, my lord.
Yes, buddy.
Any person
Ha.
by any order
Ha.
any person agreed by any order. Okay, lordship got it.
1 second.
18. After 17 on an appeal, you have to prepare before DRAT.
Ah.
On limitation only, I have approached DRAT.
Yes.
Hope your lordship got it.
Yes.
Any person agreed by any order made by the debt recovery tribunal. Here I am passing this. I am passing now. Within bracket, under section 17. Now question is whether any order has been passed under section 17 of the Act. Before admission only, the DRT has stated that under section 5 the Limitation Act is not applicable to section 17. Hence, I am dismissing it. So it means to say my doors are closed. I cannot challenge the section 5 of the Limitation Act even before DRAT also. Suppose if I challenge the limitation under section 17 in section 18 before DRT, suppose DRT has got the power to cut down the delay under section 17, then what will happen to the division bench orders passed by in this regard under section 17? Delay cannot be cut down in DRT under section 5 of the Limitation Act. Admission munchene insisting for purchasing uniform class admission agilla. So that clearly is under section 17. I am not agreed by the order passed under section 17. I am agreed by the order passed under section 5 of the Limitation Act, which the DRT will not entertain. That also, instead of filing application under section 14 of the Act, suppose if I would not have challenged the auction sale notice well within a period of 45 days, if I would have approached DRT directly, then dismissal, the delay cannot be cut down even 1 day also. But here, when I approached the Honorable High Court of Karnataka, within period of 45 days, within 30 days only I have approached, then the High Court says, no, go to DRT, but agreed by the order, when I approached division also said, go to DRT. Then when I approached DRT, there was a delay of more than 137 days approximately. Against that only, I prefer division bench, I approach DRAT. My humble submission is, my lord, when such being the case, if the DRT, assuming for a while, if I comply the pre-deposit condition, now I don't have any money, I am on the street because my property has already been sold. That contention also cannot take my property which I have sold. That consideration, what sale consideration has been received from the auction purchase cannot be taken. Here, my submission, my lord, here, at page number 25, page number 25 of the order, passed by the.
You take, Rajendra,
My lord.
you take emergent notice.
Yes, my lord.
Let us see what they say.
Here, nobody, my lordship, my submission, no one as on today have challenged this, stating that 5 of the Limitation Act under section 17, when the order is not passed, pre-deposit condition will not applicable.
Emergent.
Please, my lord.
Yes.
That's reapparent. That's what I've challenged is the order passed by the district for commission minutes, whereby an order of state district forum of dismissing my complaint for non-prosecution came to be upheld. That's my legal contention is that, minutes, the concept of non-prosecution, which is otherwise available for any civil under civil, is not applicable.
What the court have said?
Yes, minutes. The courts have said, minutes, in Utopia, V. Ganesh Narayan versus Utopia Avians, it's paragraph 65.
What they say?
They say that, minutes, they
Cannot
apply
be dismissed for default.
No, minutes, what is not made expressly applicable from CPC cannot be applied based on a Latin maxim, minutes, expression unis ex or exclusa altius, minutes.
That's not applicable. Any other ground you have?
Minutes may go to pay paragraph 65 of the judgment, minutes.
60.
Paragraph 65. Because minutes 1986 Act.
No, whether the same question is already treated.
That's the question which was involved is what has not been made applicable by way of CPC. Can the consumer courts or in terms of state commission agree, forum agree?
Suppose if you do not come, what they should do?
They should either dismiss the complaint or allow the complaint. For example, as of today, the practice which is followed in our district forums is that there's no evidence affidavit. They follow.
Where is this question treated? The tribunal cannot dismiss for default in the absence of enabling provision. That is the question.
Yes, ma'am.
Can the tribunal dismiss for default a prosecution, a case on default basis? How this question is answered?
This question is not answered by any court, including the Supreme Court. But the point of law, that what is not made applicable from CPC to the Consumer Protection
No,
Act.
power to dismiss for default is not for CPC power. It is otherwise also have all adjudicatory bodies have got that power. It's not that CPC.
May make this submission that my second contention is that, my second contention is on fact. What happened is the complainant here had filed a complaint saying that during a particular operation, a gauze cloth was left in the uterus of that lady, because of which there was infection and she had to undergo a surgery where she cannot attain motherhood. Based on that, she filed a complaint. At the same time, the doctors had filed defamation suit. When she was attending to that particular court's methods, she missed appearing before this court. And within a span of 1 month, this district forum gave 3 dates within a gap of one date, methods. And then methods went
Take
ahead.
notice, let us take
Yes,
emergent
ma'am.
notice. We will examine that and make that also clear.
Yes, methods. Grateful.
Yes,
Grateful. Emergent notice.
emergent. Yes.
My lord, appeal filed by the revenue. My lord, it's a short matter, my lord, it can be. My lord, the facts are, my lord, there was a search conducted in in the case of one Srinivasa Trust. Certain materials came to be seized. It was found, my lord, the materials belong to the respondent. Then, my lord, they were forwarded to the assessing authority of the respondent by invoking 153C. Then, my lord, ultimately an order of assessment came to be passed in the name of in the case of the respondent by making additions. that came to be challenged. My lord, the first appellate authority held that the item of additions made were not based on the incriminating materials forwarded by the my lord,
The
assessing
search
authority of the
party.
searched person. And hence, my lord, unless an addition is made on the basis of the incriminating materials, my lord, the assessment
Addition,
could not have been made.
whatever addition you want to make, it should be relatable to the items that are found in the search.
Yes. My lord, reliance was made in the case of IBC Knowledge Park and Simhagad Education Society, my lord, rendered by the Supreme Court.
Ah.
My lord, revenue came up in appeal before the tribunal, and the order of the commissioner came to be, my lord, confirmed. My lord, may I take my lordships to page number?
But ಏನಿದೆ ನಿಮ್ದ್ರಲ್ಲಿ ಇದ್ರಲ್ಲಿ?
My lord,
ಯಾಕೆ ಹಾಕ್ತೀರಿ ಇಂಥವು ಅಪೀಲ್ಸ್ ಎಲ್ಲ ಅಂತ ಡಿಸ್ಮಿಸ್ ಮಾಡಿಸಲಿಕ್ಕೆ?
my lord, page number 28, ink page 28. 26 rather, my lord. Sorry,
26.
last but one para.
The Honorable Karnataka High Court in so
Other mele.
admittedly no addition to income have been made in the orders of assessment based on these two seized materials.
Then
But ಏನಿದೆ case? Section is not attracted at all. ನೀವೇನಾದ್ರು ಹೇಳಿಕ್ಕಿದೆಯಾ?
ಏನಿಲ್ಲ ಮೇಲೆ page 29, the lordship may just read 4 lines in page 29.
29 also. First para, last.
Last 4 lines will be noted, my lord. In fact, the very same addition has been made in the earlier 143. They are repeating it. The question of incrementing doesn't arise at all. Just in other words, my lord, just 4 lines in the first para. In other words, where an addition of an amount was made in an earlier.
Assessing authority shall take note of the said
page
29 ink.
Para?
First, my lord, last 5 sentences.
Before para 20.
When earlier proceedings are opened. Last 5 lines.
29 dalla?
Howdu, 29 ನಲ್ಲಿ. When earlier proceedings are opened, that income shall also be subject matter of the said proceedings. In other words, where an addition of
it is expressly provided anta being 153A of the Act, first sentence.
Your lordship may see last 5 lines of the para.
In other words.
In other words.
Where addition amount was made in earlier assessment, an addition of the same amount cannot be made again in the reassessment proceeding under 153. This is additional ground.
There are two.
This will be duplication of addition.
Yeah.
Even otherwise you could not have done. But and secondly, you had already added it. Still you want to add it again. Dismissed. See page 26 and 29.
Page 39 would be relevant. Finding of the ITAT tribunal, para 12.
Page
39 would be relevant. That is the wherein tribunal has confirmed the order of the commissioner. We have heard the submissions of the learned DR.
Para page 39, para 12 of the ITAT order. All right.
Both years same.
Eradu same?
Same. Do different assessment.
Different assessment.
Assessment years bere.
One is 14-15, another is 15-16.
One 14-15, another is
15-16.
15-16. 14-15, 15-16, second one. Yes.
Lordship, I have raised 5 questions.
The items were already added in the earlier assessment. Number 1. Therefore, duplication of addition cannot be done. Number 1. Number 2. The additions sought to be made are not relatable to items found in the search. Therefore, even otherwise could not have been added. Yes.
Lordship, I have raised 5 questions. Transfer pricing as well as non-transfer pricing issues, it may be admitted.
No, heard admitted on the following substantial questions of law. Yes.
Lordship, 26 and 27 are connected. In this case, the revenue is challenging the order passed by the tribunal. Tribunal has remanded the matter, my lord. Only one observation the tribunal makes is that on the basis of the evidence produced by the SSC for the assessment year 2008-9, you take a decision. You consider that and pass order. Well, Lordship, my only contention is that let all the contentions be kept open, the present materials as well as the transfer pricing regulations.
Confined it to only one.
Only one observations made in the earlier order.
Because an order has been passed giving effect. On two issues, it was remanded back. One, it has been reconfirmed. One, for 8-9, it has been deleted. For these 2 years also, it has been deleted by the TPO after examining the material which I have found for these years. Well, let's just see the tribunal's finding. My lord will take up 497 first.
497.
That's
But
the first year.
Can we sit after a lunch hour?
Certainly.
Okay.
Please.
Correct.
One mention.
Secretariation Act don't cover
Okay, just one mention.
Serial
number 32 can be taken up after 2 weeks.
2 weeks.
32 minutes.
Hold on.
My lord, one, your lordship's kind permission. My lords, may I submit, my lord?
Entry model work madeva. The last two matters. Yes, entry model is granted, na? Extended also. Madam.
My lords, 45, serial number 45, my lords.
Yes, we have done that.
It is Shivram Karant layout matter, my lord. By mistake,
Correct.
again it is posted.
Yes, we have extended the entry model and told the registry to examine to which
Obliged.
bench it has to go.
Obliged.
In the afternoon, no problem. Okay. Fine.
Court officer? Court officer? Court officer?
Courtmaster, sir.
Court officer.
Courtmaster, sir. Courtmaster, sir.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ ಹೇಳಿ.
ಮಧ್ಯಾಹ್ನ ಸಿಟ್ಟಿಂಗ್ ಇದೆಯಾ ಸರ್?
ಇದೆ ಸರ್.
ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಲ್ಲ?
ಹೌದು ಸರ್.
Excuse me, sir, is item 33 adjourned?
No, sir, it's there, sir.
It is there.
No, it's urgent, sir. By 4 weeks, it is urgent by 4 weeks.
Okay. Thank you, sir.
ಅವರು ಒಂದು ಸೂಟ್ ಕೇಸ್ ಅದಕ್ಕೆ ತಗೊಂಡು ಹೋಗ್ತಾರೆ ಎಲ್ಲಾದ್ರೂ ಬಾಟ್ಲಿ
Yes, sir.
Worship, these are the two appeals filed by the revenue, my lord. The tribunal has remanded the matter to the transfer pricing officer regarding certain issue. Your Lordship, the tribunal had directed the transfer pricing officer to consider the material or evidence pertaining to the assessment year 2008-9 and pass order.
It has nothing to do with the matter which is being debated.
Because it is only whether that remand was correct or not. That's the only issue here, my lord.
How paragraph?
Your Lordship may kindly see, my lord, the tribunal's order, my lord. Your Lordship, page number 28, my lord. Your Lordship is having ITA 495 of 23, my lord.
You are right.
Page number 28, my lord. Para 5.7, my lord. Your Lordship, last three lines from the below, my lord. It is also admitted fact that the margin of the assessee at 12% was compared with the comparables being 4% for the year under consideration, and therefore some value has been received by the assessee as submitted by the learned assessee representative against such destroyed products by the US Customs, which deserves to be benchmarked. We direct the learned AO to reconsider the claim of the assessee in the light of the evidences filed and to compute the margin of the assessee and assessee in accordance with law by the following principles of transfer pricing regulations. Here we don't have any problem, my lord. Your Lordship may kindly come to page number 30, my lord. Next page, my lord. In the page number 30, your Lordship may kindly see second paragraph. We note that tribunal in assessee's own case for assessment year 2008-9 on identical issue observed as under. After extraction of that, my lord, in page number 32, my lord, the last paragraph, my lord, the learned AO is directed to carry out necessary verification based on the evidences filed by the assessee in accordance with the observations of this tribunal reproduced herein above for assessment year 2008-9. Now, your Lordship may kindly see this matter is pertains to assessment year 2005-6, my lord. The tribunal ought to have kept open all the contentions open, and tribunal ought to have directed the learned TPO to consider the materials available for this period, the present period, and pass necessary orders, my lord.
This was for the assessment year 2008, 2009.
2008-9, my lord. You follow you rely upon the materials for 2008 and pass order. That is the direction. Now, the present assessment year in question is 2005-6. Now, your Lordship, learned senior clerk counsel has placed on record after disposal of this tribunal judgment, the transfer pricing officer has given effect to that tribunal direction and has passed this order. In that case, my lord, this transfer pricing officer has given that direction, has passed the order in view of the direction, my lord, dated 11/12/2024. In that paragraph number 5, my lord, he relies upon those materials of 2008-9 and gives relief to the assessee, my lord. Your Lordship, he is bound. He has been directed to follow.
That you have to challenge.
Your Lordship, that is, it will have a different, my lord. It is only because of the time limitation, my lord, he has passed this order. Now, your Lordship, what I am canvassing is the tribunal ought to have directed the transfer pricing.
Been open remand.
Open remand
is your case.
To consider the materials for the present assessment year. That's the only point.
And your friend, senior friend says it should not be open.
Because of this order, he has got already relief. He has got the relief.
Yes.
Manoj will just read, let me read from para 6 of the tribunal's order. Ground number 6 to 10 are in respect of the administrative service fee paid by the assessee. The learned AR submitted that the service agreement for rendering of administrative services dated 10th November 1999 and the documents evidencing the support services provided by the AE to the assessee regarding the customer referral program is placed at so-and-so of the paper book. It is submitted by the AR that the assessee has also furnished the total cost incurred by the AE towards the common group services and the basis of allocating the same amongst the various group entities. He placed reliance on various decisions of the tribunal in the SSC's own case, where the issue has been remanded to the AO for de novo verification. So the evidence which we had filed was for the year, but we placed reliance on the tribunal order for the earlier year that it has sent back for verification basis the evidence for each year. It cannot be that it is the evidence of a subsequent year which can be the basis for this claim. Now please see the next. ITAT order for 8.9 remanded by the ITAT to the TPO and the adjustment subsequently deleted entirely by the TPO. TP order for 4.5. All international transaction, including payment of administrative fee, concluded to be at arm's length. TP order for assessment year 11-12. All international transactions, including payment of administrative fee, has been concluded to be at arm's length. TP order for 12-13. All international transactions, including payment of administrative fee, has been concluded to be at arm's length. Now see the department's argument. On the contrary, the learned DR submitted that the issue may be remanded to the AO to be verified in accordance with the observations of the tribunal for assessment year 8-9.
Case. Correct.
So you verify the details for this year in accordance with the principles laid down by the tribunal
In those cases.
while disposing of this. That's all. What could be the grievance against that?
No, he says it should be open remand.
No, but
There
it
should
is.
not be
Why
any
not?
restriction at all.
Thus, he says the AO is directed to carry out the necessary verification based on the evidence filed by the SSC for this year, but in accordance with the observations of the tribunal for 8.9. Because the tribunal has laid down certain principles. My lord will just see the tribunal's order
In those cases.
for 8.9. Please see that.
Sorry. Sorry.
Now just see page 19 of the order.
This is one of the enlisted orders.
Yes, ma'am. This is the tribunal order for assessment year 8.9.
Follow the 8.9.
Now just see para 11.4 where the conclusion starts, page 19.
We have considered.
They have considered the rival submissions as well as the relevant material on record. We find that the powers and jurisdiction of the AO and the TPO under the provisions of Chapter 10 along with Rule 10B has been examined by the Delhi High Court in the case of EKL Appliances Supra in paras 21 and 22 as under. Then they have extracted from the Delhi High Court judgment. We further note that the coordinate bench of the tribunal in the case of Festro Controls versus DCIT has followed the above view in paras 12 to 15 as under. Then they have extracted from that.
Thus in view.
Thus, in view of the judgment of the Honorable Delhi High Court, as well as the decision of the coordinate bench of this tribunal, the TPO is not empowered to determine the ALP at nil, though the quantum size has to be decided along with the ALP to be determined as per Chapter 10 of the Act. The SSC has filed additional evidence in support of its claim that the AE has rendered services. Since the additional evidence filed by the SSC is relevant in material document in adjudicating the issue, and further when the TPO has not determined the ALP as per the provisions of Chapter 10 as well as the rules, therefore in the facts and circumstances of the case as well as in the interest of justice, the issue is set aside to the record of the AO TPO for adjudicating of the same after considering the relevant evidence as well as in the light of the above observations. So in that year, we filed additional evidence before the tribunal for the first time. Here, the evidence was on record. So the tribunal notes that the evidence is there. The tribunal says you will now examine this evidence which is there in the light of the principle laid down in 8.9, basis Delhi High Court and Bangalore Tribunal. What could their grievance be against that? Because they to remand it also, they have to give some reason as to what is the scope of the inquiry to be conducted. Therefore,
where scope is restricted now? How you argue that scope is restricted? On what basis you assume that the scope of remand is restricted?
And please see the order giving effect. Just for a moment before my learned friend answers. Please see the order giving effect. Just see para 7.
The taxpayer furnished.
The taxpayer furnished the documentary proof in support of the administrative fees paid to its associated enterprises. The taxpayer furnished the breakup and the basis of allocation of costs by the parent entity based on which the payment has been made. The documents furnished by the taxpayer in support of its arguments are as follows: service agreement, description of services rendered, examples of services rendered, which include email correspondence and their excerpts, certificate of an independent auditor certifying that the cost allocation was made as per the OECD TP guidelines, other supporting documents including the assessment order for other years in the SSE's own case. After carefully considering the material on record, it is concluded that no adjustment is required under section 92C. So my lords will see that I filed evidence for the year. He considers that and then says that no adjustment is required. And
This,
my lords
this
will
order, this order he has already made now.
yes, well, on the remand.
But this you have not put in challenge.
Because it will be always subject to this appeal, my lord.
Subject
If I
to-
succeed here, he will
This
reverse it. my
automatically
lord.
goes.
Yes, my lord.
This is pursuant to the impugned order.
Yes,
This
my
is-
lord. Yes, my lord. Your lordship, substantial question of law raised by me at page number 5, my lord. The relevant substantial question of law at number 2, my lord. Page number
No,
5.
whatever evidence is already available on record
Yes, my lord.
for the assessment years in question.
Yes, my lord.
Well, beyond that, what you want to do?
Your lordship, why I filed the appeal before this honorable court on 2 reasons. The tribunal, without looking into the materials or the findings given by TPO for that assessment year and the Commissioner of Income Tax Appeals, simply remands the matter. First point, my lord. Without considering the findings of both the below authorities, remanded the matter.
No, as such, you have no grievance against remand at all, going by your own version. You only, your grievance is the restriction of scope of remand is your contention.
That is also one ground, my lord. One more ground is that in second substantial of question of law, what I have stated is the the tribunal, without going into the findings of the first appellate authority as well as the transfer pricing officer, has remanded the matter. Second question, may I read, my lord?
Page number?
Page number 5, my lord.
5.
Whether on the facts and in the circumstances of the case, the tribunal's order can be said as perverse in nature in not considering the findings of CITA as well as of assessing officer or transfer pricing officer, whereby it is specifically held that ALP ought to be determined on basis of the price which the goods would fetch on the date of sale if sold or to unrelated parties.
Because actually questions 1 and 2 don't arise in this year at all.
Why?
Because that was only in 3-4.
Which one?
My lords, there were 2 odd. There was the tribunal disposed of 2 years by a common order. Assessment year 3-4 and 5-6. This appeal is for 5-6.
Correct.
The first 2 questions arose only in assessment year 3-4. What my learned friend earlier read, where he said we have no dispute about that remand. My lord will just recollect. Just go back to the tribunal order. My lord, let's just go back to the tribunal order for a moment. Sorry. My lord, my learned friend read para 5.7. At
We
page
appreciate-
28 or page 29, I think.
It's also admitted fact. Last 5 lines.
Yeah, that's right, my lords.
Margin of associate 12% was.
That is with regard to a sale which arises only in 3-4, not in 5-6. 5-6 does not have this issue at all. So questions 1 and 2 are completely.
They are not the issues. for
Well,
that
that
particular-
because there is also issue of demand for other assessment here of common substantial question of law in both the cases, my lord.
That's all right, but how
For
these questions
for
arise?
this question number 6, my lord. Question number 6, my lord. Whether on the facts and in the circumstances of the case, the tribunal's order can be said as perverse in nature in directing the transfer pricing officer to carry out necessary verification based on the evidence filed by assessee in accordance with the observations of the tribunal in assessee's own case for assessment year 2008-10 without considering the findings of assessing authority and transfer pricing officer and materials on record.
Where has he said this? Just show that.
Your Lordship, the tribunal, when remanded the matter, my lord, has simply said that the tribe.
No, show that. Whether what he says is true.
Whereas the DR himself, my lord, will just see, I'm sorry to again repeat, because please see the department's argument.
Ah.
My lord, just go back
to page.
Para 6.2. 6.1, sorry, what is it?
6.1.
Page 30, my lords.
Yes, sir.
Now just see at the bottom of page 29, sorry.
On the contrary.
On the contrary, the learned DR submitted that the issue may be remanded to the AO to be verified in accordance with the observations by the tribunal in the SSC's own case. How can now they have a grievance against it? The remand. This was the only argument of the department before the tribunal.
In accordance with the observations by the tribunal.
The principle laid down following a Delhi High Court and the tribunal order in the case of Foster. In the 8-9 order, the tribunal in 8-9 did two things. The tribunal said these legal principles are settled and you filed additional evidence, let him consider the additional evidence in the light of these legal principles. In this year, the evidence was already there. All they've asked him to do is to consider the evidence for the year in accordance with the legal principles.
Which is already on record.
And it is open remand. Therefore, it is an open remand you have to consider based on well-settled legal principles.
No, do you agree? Just we want to have clarification, sir.
Yes, my lord.
Is it a limited remand or absolute remand?
According to me, what the tribunal has said is that you will consider this matter de novo, but apply these legal principles enunciated in these judgments.
So it's an open remand only. We will record that and we will dispose of the matter. He agrees that it's an open remand. When you are saying it's a limited remand. If it is an open remand,
yes,
all relevant factors would be considered by the remandee and pass fresh orders. Where is the grievance now?
Please.
And my lord, the 8-9 order of the tribunal, they have accepted, they have not even filed an appeal to this court.
In 8-9, they have not filed appeal.
They have not filed. So my lords will just see, we are today concerned with 3-4 and 5-6. The in-between year 4-5, they have accepted. 8-9 tribunal order, they have accepted. TPO himself has not made an addition for the other years, which the tribunal records in para 6. Just for these 2 years that this issue arises. All the other years, it has been accepted to be at arm's length.
You give some time, sir. We will read again and come back. Some date you may choose. Convenient date for you. Whichever date you want to.
And I will also get it ascertained, my lord, regarding this as well as the other assessment here where the runner is.
No, if you have not feel again in respect
my lord.
of assessments for the
I don't,
other
I
year,
cannot argue, my lord.
and you are very selective in respect of 2 assessment
Because
years, then he is justified in saying that you cannot challenge this
I will
also.
get some instructions, my lord, on these 2 submissions.
Would 7th be all right?
7th February.
Yes.
You have to come from
Bombay. Or 11th, whatever is convenient to me.
Today 11th. 11th, all right, sir.
Before that, if he files any.
While coming, just bring a small note of your submissions.
Certainly.
So that it helps
Please,
you also.
Please.
Call on 11th. Well, can you be selective?
Yes, if
Even in law, suppose if you have allowed some particular substratum to continue as it is for few years, and in other assessment years, of course, res judicata
should be
may not
consistent,
applicable, but how? There should be some
if
fair
it has
stand on the
reached
part of the
attained
department
finality, my
also.
lord, if that order has reached attained finality, my lord, then
you cannot.
Unless there is some new evidence is there, fresh evidence is there.
What fresh evidence? Whatever evidence they have already placed for the years in question, based on that, the remand has to be decided.
Yes,
your friend says.
Monetary limit, just he wanted me to ascertain, my lord.
Monetary limit not kept.
It is there, my lord, more than this.
Monetary limit is above. Okay. 27 also same.
Yes, sir.
Sir, all right, on 11th we'll have it. Okay.
Right.
We'll also read and come back again. Yes.
My lord, appearing for the appellant.
Devan.
This is an appeal for the assessment year 2021. The tribunal in this order relies on the earlier tribunal decision for assessment year 13-14, my lord. My lord, the appeal against the tribunal order for AY 13-14 is pending before my lords.
It
And
is pending.
It is admitted, my lord. This may also
Identical
be admitted.
questions of law have been admitted.
Illidavalli, same questions of law.
Same questions of law.
We are told at the bar that ITA number
My lord, ITA number 484 of 2022.
482 of 2022.
484. 484.
So having a substantially similar fact matrix has been admitted on the similar substantial questions of law by the coordinate bench wide order dated
By order dated 12/6/2023.
12/6/2023. First off, if that be so, this appeal also needs to be and accordingly admitted on the following substantial questions of law. Call this matter along with ITA number so and so.
Great.
Yes.
Lords, the appeal relates to disallowance of PF and ESI.
Disallowance of PF and ESI.
In the case of a works contractor, similar matter has been admitted, my lords.
Admitted. Yaru.
I'll take notice.
Sorry.
ತಿರುಮಲೇಶ್ ಅವರು ತಗೊಂಡಿದ್ರು ಅವರಿಲ್ಲ
Issue notice. Shri
ಅರವಿಂದ್ ಚೌಹಾಣ್.
Arvind Chavan, London Panel Council accepts notice. First off, we are told by the Learned Council appearing for the petitioner, appellant, that in an identical set of facts, substantially in an identical set of facts, that is in ITA number 117 of 2024, correct?
Yes.
Or comma, the coordinate bench of this court, wide order dated, date in
25/3/2024.
2024 has admitted the appeal on similar substantial questions of law. First off, in view of that, this appeal is also admitted on the following substantial questions of law.
Only one
Call this
prayer.
matter along with
One prayer, my lords. Question number 2 in my appeal here. It relates to levy of interest under section 234B. My submission, my lords, are that there was a judgment of this honorable court. Because of that, this amount I did not include for the payment of advance tax.
Anyway, we'll consider when matter comes for.
Okay.
Call this matter. Copy on padi. Okay.
Agli Tirumalesh ಅವರು ಕೊಟ್ಟಿದ್ದೆ ಇನ್ನೊಂದು ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ.
ಮಾಡಿಸ್ಕೊಡಿ. Yes.
My lord, revenue appeal, my lord, substantial question of law on page number 9. My lord, essentially, my lord, additions made under 153A.
153A.
So it needs to be admitted, my lord, it has to be argued.
Appeal admitted on the
Page number
following
9.
substantial questions of law. Illa no?
ಇಲ್ಲ. May I make one submission, my lord?
Issue note.
Serial number 37. It has come in final hearing, my lord. That has not been admitted, my lord. Transfer pricing matter needs to be admitted first.
37,
37 ನಲ್ಲಿ.
Nodi. 37
My learned
is
friend from the other
admitted on
side
the
is.
following substantial questions of law.
Questions, my lord, in page number 10.
ಮೂರಿದವ?
More ಇದೆ.
Law. Since similar questions are being debated in other ongoing matter. Okay. Pradeep. Unfiling of certificate copy as per order dated 2022. Vacating the stay. Yaribru ilva? Sunita Srinivas, None appears for the parties. Call after 2 weeks. In the meanwhile, compliance to be made. ಹೌದು, ಮತ್ತೆ ಈಗ ಬಂದಿಲ್ಲಲ್ಲ ಅವ್ರು. ಹಾ. Yes. Next.
Lord, I approve the petition.
Ah.
It's a revision petition, Lord, arising out of the first assessment period
Ah.
under the VAT regime.
Okay.
Lord, there are two issues before your lordships. One issue, Lord, according to me, it is covered.
Admit ಆಗಿದೆಯಾ?
How be that? It's admitted. It is for the final rate, and it should not take more time.
Ah.
Lord, the first issue, Lord, pertains to levy of VAT at higher rate of tax, considering it as an unscheduled goods under the VAT Act.
When they are scheduled.
Unscheduled goods, but which is contrary to the provisions of the CST Act. Now, Lord, this has been settled.
Goods are treated as being unscheduled
Please, Lord.
and therefore they have been subjected to higher rate
Higher
of
rate
levy.
of tax
Okay.
at 12.5% during the first year. But in this case, it's a case of works contract, where iron and steel purchased by me and then utilized as reinforcement steel in the construction activity should be taxed, my lord, at 4%. It should not, because iron and steel is considered as a declared goods under section 14 of the CST Act.
For declared goods, what is the tax?
It is, Lord, it should not exceed 4% during that year.
Which is the section?
Lord, section 15 of the CST Act.
They have levied at what rate now?
Now, Lord, they have levied at 12.5%.
Because it's treating them as unscheduled goods.
Lord, please, Lord, in the first year of VAT Act, and if your lordships could see,
But
there is a
VAT Act.
section 4 of the VAT Act provides for, Lord, that I have only one old act, Lord.
you have
It's
that.
not,
This is not applicable.
please,
Third or this one. Xerox copy ಇದ್ರೆ ಕೊಡಿ ಸಾಕು.
Xerox see that.
ಕೊಡಿ ಸಾಕು.
It's section 4, if your lordships could see, which provided for.
ಇಲ್ಲಿ ಕಲ್ ಔಟ್ ಮಾಡಿಲ್ಲ, ರಿಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಸೆಕ್ಷನ್ 4 ಅನ್ನ.
Senior was to say, we should never extract the provisions in the petition.
Because law should not be pleaded ಅಂತ.
Please.
Yes.
Section 4, if this was the, Lord, the charging section under the VAT Act. Liability to tax and the rates thereof. Every dealer who is or is required to be registered as specified in sections 22 and 24 shall be liable to pay tax on his taxable turnover. Clause A, Lord, in respect of goods mentioned in schedule, second schedule, third and fourth schedule, rate is provided.
B.
B, Lord, in respect of other goods at the rate of 12.5%. Lord, admittedly.
They bring your goods under B.
Please note, because works contract was not contemplated.
Huh?
Works contract, levy of VAT on works contract was not contemplated in the first year. It was left over. So they brought it under clause B. This has been amended. In the new act, your lordships will get, Lord.
With effect from?
With effect from 1/4/2006.
1/4/2006.
Yes, Lord.
This levy in question is for which year?
5/6, first year, Lord.
After the post amendment?
Post amendment. I mean, pre-amendment, Lord. I'm sorry.
Pre-amendment.
Pre-amendment.
But
Only 1
pre-amendment works contract are not included at all.
No, Lord, that is what it is, Lord. But since it is not brought into tax under this section 4, they have levied tax under clause B in respect of other goods at 12.5%.
Because B is residuary.
Residuary, works contract has been there under the sales tax regime and it continued under the VAT regime, but for this year, and even under the GST, it is there. So by oversight, Lord, works contract, a deemed transfer was not included in this section 4 for that particular year alone. But if now we were lordships will see the amended provision in section 4.
Subsequently added.
subsequently added.
Is it clarificatory or it is only substantive?
Lord, obviously, Lord, it's a charging section, it has to be substantive. But Lord, as your lordships are aware, the first Gannon Dunkerley was the only case which held against the state, which said no, there cannot be any sales tax on the deemed works contract, because works contract, when it is transferred, the taxability, it is on the immovable property which cannot be taxed under entry 54. But subsequently, law was amended. Let 366/29A was added to bringing a friction. Let to consider this deemed transfer as a sale by segregating the goods portion at the
From
time of
the-
incorporation.
From services.
From services, and the goods which are incorporated in the works contract have been treated to be taxed under the sales tax as well as under the VAT Act. So therefore, Lord, on that aspect, I'm not disputing that it was not taxable during the year 2004-5.
It is taxable, but
5,
not at 12%, but 4% is your contention.
So far as iron.
Say it is 4% under which it has to fit.
Right. If your lordships could see section 4 of the amended provision,
Padi.
the VAT Act, that is there in all other acts.
ಇವನ್ನ ಅಷ್ಟೇ ಜೆರಾಕ್ಸ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ರೆ ಎಷ್ಟು ಈಸಿ ಆಗ್ತದೆ ನಮ್ಗೆ ಇದು ಹುಡುಕೋದು ಅಂದ್ರೆ ದೊಡ್ಡ ತ್ರಾಸ ನಿಮ್ದ್ರಲ್ಲಿ.
I'm sorry.
We are not that familiar with this branch of law.
I'm sorry. I should have. Class B amend ಮಾಡಿದ್ದಾರೆ section 4(1)B.
4(1)B in respect of declared goods as specified in 14 of GST at the maximum. 4(1)B na?
1 declared goods.
Declared goods
ಹೌದು.
as
ಇಲ್ಲಿ
specified in
yes.
section 14.
At the maximum rate specified for such goods under section 15, and then your lordships will see B3. All other goods at the rate of 14.5%. For some time it was 12.5, for some time 13.5, then 14.5. But that aspect is not in
That proviso is what that
blood. Provided that the rate of tax in respect of declared goods as specified in section 14 shall be 4% from 8th day of April 2011 to ಅದು 5%
a particular
amend
period
ಆಗಿತ್ತು.
ಗೆ.
So ಅದಕ್ಕೋಸ್ಕರ 4% ಇಟ್ಕೊಂಡ್ರು ಆ particular period ಗೆ. Subsequently, my lord, it was enhanced to 5%.
C is
In respect of transfer of property in goods, whether as goods or in some other form,
involved in the execution
involved
of
in the
works
execution
contract.
of the works contract specified in 6th schedule. 6th schedule ಅಲ್ಲಿ specify ಮಾಡಿದೆ works contract ಗೆ rate of tax ಎಲ್ಲ. So therefore, my lord, it has been taxed under this provision. 4(1)B. C.
What you say is 4(1)B
1.
1
Yes.
was absent for the
Year
year
5, 6.
concerned.
First year.
Therefore, in the absence of that, you could not have levied 12.5% tax at all,
Because
although 4% is admissible. That's your case.
yes, because it violates section 14 and 15 of the CST.
ಹೆಂಗೆ violate ಆಗ್ತದೆ?
But section 14 says, specify certain goods as of national importance, and they are called declared goods. Now, section 15 says, the rate of tax leviable by all the states throughout the country should not exceed particular rate on these declared goods. Those goods which have been declared under section 14.
And goods involved in this case are of that.
Iron
category.
and steel comes under 14(6). So therefore, Supreme Court has clearly said, and Article 286(3) says, if there is anything specified by the central legislature, it has to be, if there is a rider there, it has to be applied by all the states. So therefore, Lord, even if you specify a higher rate of tax, which is in your domain, the state, Lord, should not have levied more than 4% tax on iron and steel alone.
There is
So you
tax
should-
liability.
Yes.
Your grievance is as to the rate of tax.
Rate of
Since
tax,
they treated those goods to be declared goods,
they have not treated, they have
they
ignored.
treated it as residuary class.
Please,
They have levied 12.5%.
please.
In fact, they ought to have treated it as declared goods in terms of 14-15.
Please.
Then you would have been entitled to, liable to only 4%.
not 12.5%. Tribunal says assessing authority does not comment on this. He simply levies 12.5% on the entire turnover.
That you
There were-
challenged before the tribunal.
Yes, it
How
was.
tribunal proceeds, what's the reasoning?
Tribunal says in the first year for 2005-6, section 4 was absent on this. So therefore, there was no exclusion provided under section 4. We cannot give you that benefit is what the tribunal says. My respectful submission, there are 3 judgments of Honorable Supreme Court which say in relation to the levy of tax on works contract, state is empowered to levy or prescribe any rate of tax, but that rate should not exceed the rate specified under section 15 insofar as section 14 of CST is concerned.
In respect of goods of national importance.
Please. There are 3 judgments. Issue is covered by that.
Aditya, you appear for respondent. You admit that for the 2004, 5 or 5, 6 the absence.
5-6 first year.
5, 6, there was no provision at all.
Dispute at all. The issue is twofold. One is that I am bound by the judgment of this honorable court in Nandi Construction.
What it said?
So Nandi Construction says that once an assessee claims something in their return, I cannot give them any benefit that is larger than that. And that is in the same vein as your lordship saw in Centum Industries. And it is not in dispute, my lord, even up to the tribunal, that the returns reflect a consolidated, unbroken amount of 12.5% filed by them. Your lordship may kindly take.
That is a rule 3.6. 3.6.
Section 35 of the VAT Act. Requirement to file returns. And then rule. Lordship may kindly take paragraph 6 of this.
Have you seen this, Nandi?
Yes, ma'am. I am
Yes.
aware of that.
Yes.
But that is not applicable to the present case.
Let us.
License.
Yes.
The main issue to be decided by this court is as to whether the petitioner can be granted benefit over and above what has been claimed in the returns filed by the SSC for the relevant tax period. Admittedly, the claim of the petitioner in its returns filed for the relevant tax period was at 45% towards land tax, though the assessing officer allowed only 40%. The first appellate authority granted the benefit of 45% towards land tax. Question now to be decided is whether unless a claim is made by the assessee in his return and without the same being revised or modified to form the revised return, any benefit beyond the benefit claimed in return can be considered and allowed by the authorities.
So claim in the return is a must, is a sine qua non.
Yes, ma'am. But the entire
Or amended return hakboda?
Provision is there.
That you have not filed.
But so far as this judgment is not applicable so far as the rate of tax is concerned. Rate of tax, everyone is bound by statute, not the return, declaration in the return. I might say, oh, I am liable to pay only 1%. That doesn't mean officer will keep quiet.
No,
They're
for
bound
that
by-
you should, but if suppose.
It's a deduction or a claim which I am saying I am not liable to pay tax. In case it was a deduction.
So far as the, I'll come to paragraph 9 months. If there are 2 aspects, one is whether I can give any assessee a benefit that is claimed, that is not claimed in the return, whether be it rate of tax, whether be it any deduction, whether it be any rebate, whether it be input tax credit. They have not done so. Revised return also is not done so. There is another aspect which I'll take your lordships to, Mahafatlal Industries. The presumption is that it is passed on to the end customer.
Unless country is proved.
Burden is on them to prove.
Where have you stated that you are not passed on this tax liability to your customers?
But the contract was very clear with the customers, which was not the place before the assessing officer as well as before the tribunal. That
Where do you have that contract with you?
that I have not produced, Lord, but
That is necessary for us.
that I shall produce. Our Lord, we have not passed it on because it was a duty upon us to pay taxes. We have subsumed or consumed those that liability into our profits. We have not passed it.
That is the That is.
But all if
You
I
have
have
not
passed,
passed on.
illam.
That's a
If you are not passed, then it amounts to against doctrine of unjust enrichment.
Unjust enrichment agala, I have paid it out of my profits. What is not liable to be paid is collected from me.
Now, unless you have passed on to your customers, that argument is not available to you.
Lord, it's not like that, Lord.
Ah.
Let us say, Lord, if the contract value is 100 rupees,
Correct.
I have kept my profits as 20 rupees.
Correct.
Whatever is the tax liability, I have told my customers that it is my liability. I will take care of it.
You produce
So
your
out of this
contract. You
that I
produce
shall
your
not.
deed
Even
of
before the
contract.
tribunal, it was placed before the tribunal. I shall.
It happens like.
That is not the issue, Lord.
If there is a breakup, they are charging their customers 120 rupees. Out of that, my lords, let us say 12.5%
Tax component.
is tax, 12.5 rupees is tax component. 100 is their cost. They are making 8 rupees or 7 rupees 50 paisa as the case may be. Now, in fact, unless there is an invoice with the customer that says, this is the cost, this is the amount, on that I have collected 4%, that 4% is to be therefore paid to the exchequer. And then the hit of 12.5% comes. They absorb that. That is believable. For them simply to say, I will absorb the tax, it is deemed to be within the assumption it is passed on.
Unless you produce your contract.
Lord,
Contract deed.
I have no difficulty. I shall place it before your lordships. But that was not the ground.
No, that's all.
The
But
assessing
we want to
officer,
know. Anyway,
that shall place it
this
before your
court
lordship.
wants to ensure
Please.
that you do not become
Lord, I definitely.
at the cost of others.
Please.
That way. That is a
It's not a-
doctrine of unjust enrichment.
ಅದರಲ್ಲಿ ಈ question ಅಲ್ಲಿ ಬರಲ್ಲ ಸ್ವಾಮಿ. ಈ
No.
case ಅಲ್ಲಿ ಬರಲ್ಲ. Your lordships may kindly see the observations of the assessing officer.
No, he has not said that.
Since I have not made a claim, given the details of 4%,
Anyway,
it is
court
not.
wants to know. This court wants to know.
That is precisely the point, my lord. They
Correct.
claim 12.5%. There is no segregation as to what is 4%, what is not 4%. Post facto, my lords, I cannot give a benefit that is not in the return.
Let us see that document. At least
I'm
that
obliged.
will throw light.
I'm
In this matter, my lord, serial number 41, I appear for the appellant, my lord. My lord, the senior counsel.
43.
No, this is different matter.
This is 43.
Apologies, my lords.
When you want this matter, when will you produce that?
Blood, next week one beda Prayagraj ಹೋಗ್ತಿದ್ದೀನಿ.
2 weeks.
After that is fine.
All right, pray for us also. Call this matter week after next, so that petitioner shall, the appellant shall produce the contract document in question. A copy of contract document in question. Since the learned AGA has raised the doctrine of unjust enrichment in the matter. Okay.
Lords, if I may be allowed to make a mention, my lords.
Yes, brother.
Lords, serial number 41, my lords, I appear for the
I
appellant.
appear for the respondent. I'm ready, my lord. Your lordship, by every time they
ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಕೇಳೋಣ ಏನ್ ಬೇಡವಾ?
ಯಾವಾಗ್ಲೂ time ತಗೊಂತಾ ಇದ್ದಾರೆ. ಹೋದ್ ಸತಿ
Why, brother, you are doing like that?
they have
You
taken
are
the
putting your
stay.
sister to lot of difficulty.
From
Why are you?
22, they have taken the stay. Every time they're using some excuse or the other. Last time senior counsel was not well. Adik Munche, they're taking time. This has been happening repeatedly.
Lords,
If you may see the order sheet also.
Lords, in fact, my lords, senior was ready, my lords, today, my lord. He had to urgently travel back home because his health is not keeping well, my lords. He is of
See,
old
this
age.
has been
He had
happening
to-
regularly for us.
He had to travel back
Health
home.
ಆರಾಮಿಲ್ಲ.
Health ಹೋದ್ ಸತಿನೂ ಹಂಗೆ ಬರ್ದಿದೆ.
Lords,
Same thing has been happening.
Matter may be
Same
taken.
thing has been from 22, they have taken a stay and I'm put to so much of inconvenience. I'm a government company. In the OSA, in this company petition, I was successful. They have just come deposited 10 lakhs and then gone. This is lease rentals, which
All right, ಯಾವಾಗ ನಾಳೆ tomorrow ಇಟ್ಕೊಳ್ಳೋಣ?
My
I'm
lord,
ready for tomorrow.
taken up
One
tomorrow.
second, why are you not allowed? No, first this matter before some other bench.
No, I apologize, my lord. I apologize, my lord. It is not a thing. Any day that is convenient for this bench, please.
Sorry.
whatever they,
ಪರಮಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Thursday.
Brother, which day you want to?
Not any date, any tomorrow or day after.
ಹಂಗ ಹೇಳಿದ್ರೆ any post this matter any day.
Thursday.
ಅದಕ್ಕೆ ಒಂದು ಡೇಟ್ ಕೊಡ್ಬೇಕು.
Thursday, my lord.
ನಿಮ್ಗೆ
Maybe
ನೀವು ಕೇಳ್ತಾ ಇರೋದು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್, ಅವ್ರು ಅಪೋಸ್ ಮಾಡ್ತಾ ಇರೋದು.
please,
ನೀವು
my lord.
ಕೊಡ್ಬೇಕು ಡೇಟ್.
Maybe taken up on
ಆ
Thursday.
ಡೇಟಿಗೆ ಮಾಡ್ಬೇಕು, ಮತ್ತೆ ಟೈಮ್ ಕೊಡಲ್ಲ ನಾವು.
On Thursday, my lords. Maybe taken up on Thursday,
30th.
30th, my
ಇದು
lords.
ಒಂದೇ ಇರಲ್ಲ, ನಮ್ಗೆ ಬೇರೆ ಬೇರೆ ಇರ್ತದೆ. ಇದು ಒಂದೇ ಇರಲ್ಲ, ಇದಕ್ಕಿಂತ 10 ಪಟ್ಟು ದೊಡ್ಡ ದೊಡ್ಡ ಕೇಸ್ಗಳು ಇರ್ತದೆ. ಅದಕ್ಕೆ ಅಷ್ಟೇ ಕೇಸ್. 13th. On 13th February.
Please, my lords, please, my lords.
This matter on 13th February at the request of the Net Council. So and so on health ground. Finally.
Please, my lord.
ಮತ್ತೆ ಅದೇ ಹೇಳ್ಬಾರ್ದು.
Yes, my lord.
ಅದನ್ನೇ ಹೇಳ್ಬಾರ್ದು, ಹೊಸ ಗ್ರೌಂಡು ಹೇಳ್ಬಾರ್ದು ಅಡ್ಜಸ್ಟ್ಮೆಂಟಿಗೆ.
Yes, my lord.
Much obliged.
Serial number 44.
44? Yeah, that's right.
44, the
Second week of February.
next matter. My lord, the writ itself is not maintainable. Under consumer court order, they have challenged before this honorable court. When there is an effective, efficacious remedy, please, my lord.
Court officer. Court officer.
Madam.
What happened to serial number 39?
Adjourned by 2 weeks, madam.
Okay, thank you, sir.